Your Before my learned friend starts, Malak, sir, we have now been given a new set of another volume of the pleadings of the argument of the learned solicitor, which was not with us. With 2,000, how many pages of document? Over 2,000 pages, Malak. That's all right, but I mean, unless we have that, how do we do this?
These are just enactments that we have put on record. It's a separate note which is about 35 pages. It just has a list of all the old universities. The documents may run into 2,000 pages, but that may not necessarily be relevant. We put them on record to.
There's nothing to do with the pleadings. Now it's a nationalist thing that the whole thing is being. Nothing to do with the pleadings of the case.
There is absolutely no new argument, in fact, in the additional note.
Well,
all the arguments.
When the Solicitor General takes us through the that, we'll
That-
see
that
what,
stage
what
I'll
is to be.
I appreciate.
If most of it is just acts and other
I
things,
am
may turn out that
comfortable with that.
it's of no consequence. Really.
But the arguments are not based on anything that's in the pleading.
Oh, I see.
That's-
We'll bear that in mind. Actually.
Yes, please, thank you.
Now we've really heard very substantive arguments from all the counsel who have preceded you. So we don't want to deny you the opportunity to argue before a 7-judge bench, but brief, so that we can then call upon the other side.
We have stuck to the pleadings, my lord. That's very important. Because both in the original submission and the latter one, it's all in the air, man. It's something entirely new.
So that's important to stick to the pleadings, because though it's a constitution bench, I mean, we can't sort of have something, then we might as well be reading, website and deciding the case. We have to confine ourselves to what is on the record as pleadings, and we'll observe
The
that.
arguments by Google, my lord.
Your Lordship, please. Whatever time, my Lord, I have, I'll try touching 4 points, my Lord, very briefly. One, how this Anjuman Rahmania had approached in 1981. And second, some submissions in supplement to what has been argued on educational institution of their choice, my Lord. I'll just take few paragraphs.
So can you just, to start with, formulate your 4 points so that then we can go to each one of them. So you can just formulate the proposition, then we can go to everything that you want to know.
After this Anjuman Rahmania's approaching this honorable court, I'll come to the educational institution of their choice has been, so this will, first point will be educational institution of choice includes university, and I will corroborate with the judgments of this honorable court. Second, my lord.
Just 1 second. Yes.
1920 Act is in the nature of recognition of an institution rather than
1920
Act, AMU Act, my lord, is in the nature of recognition within the system, my lord, for the purpose of making the degree usable. So there are views of this honorable court on this, how recognition is important for an institution. So my submission is that the act is nothing but a tool of recognition. Third, my lord, the entire chapter of fundamental right, my lord, part 3, apart from various other aspects, also talk about adjustment of group rights for enforcing affirmative action, my lord. And when your lord
speaks of
group rights, my lord,
adjustment of group rights,
for affirmative action, my lord. And I will touch little bit to just say how the Union of India even today taking that this is a matter of national unity, national integration, my lord. So that I have pointed out few pages from judgments of this honorable court,
That's
how
the
it
third-
was
that's the
rejected earlier.
Third proposition. And then fourth,
These are,
three propositions, basically.
my lord.
Fair enough. Now let's go rapid fire about, what you want to cite
Anjuman
for.
Rahmania, my lord, is,
So we take the first.
yes, my lord.
Education institutions of their choice includes a university. That point, I think Mr. Kapil Sibal has substantially argued.
May I-
Is there something else that you want to supplement on
I-
that point? You feel free to tell us.
Before I go there, my lord, my Anjuman Rahmania petition of 1981,
Right.
before this honorable court, was just closed without, despite TMFI saying that it will have to be decided by regular bench, was not decided. So I just want to point it out to
Right.
the lordship. The lordship may have this volume 1E, my lord.
Chief Justice, I've graduated to the tablet.
I noticed that. I mean,
I thought I'd tell you that since you told me in open court.
that's excellent.
If your lordship has volume 5A, page 552, your lordship may have it. This is TMA, my lord,
Volume
5A, 552. There is a cases description, my lord. Writ petitions 300, just after cause title. Writ petition 5457 in the first line, my lord.
Yes.
This is that petition of 81. And this was before 11 judges, honorable 11 judges, my lord. And thereafter, if your lordship comes to page 779, the same judgment, my lord.
What was the issue raised by you in that?
My lord, basically the similar issue which related to right to administer. This was the issue in Basha also.
Yes.
And the same issue was here. And my lord, one thing I just want to place before your lordship, when I came in 1981, there were at least 9 judgments to say that you can administer. Regulatory controls, all right. 9 out of 9 judgments, my lord, 9 judges, which is Xavier, 7 judges, Kerala Education, 6 judges, 5 judges.
Just tell us, come again. How many?
My lord, total 9 judgments, my lord, till 1975, from 57 to 1975. Kerala Education, my lord, first. 7 judges. Siddharth by 6 judges. In between, this Aziz Basha, my lord, honorable 5 judges. Then Father Proust, my lord, 5 judges. Right Petro, 5 judges.
Reverend Patro, right?
My lord. This is 69. 1969. Mother Provincial, my lord, honorable 6 judges, 1970. (1971), my lord, DAV, honorable 5 judges. (1974), my lord, Ahmedabad Xavier, honorable 9 judges. And then comes, my lord, Gandhi Faizyam, 3 judges, 1975. I had gone to the Allahabad High Court because I had problem in administering it.
So just to go back, Father Proust is which year?
Father Proust is, my lord, which year? I'll just.
Since you have given us
Father, Father Proust is 1968, my lord, 13th of September.
right, Basha?
Pasha is October 1967.
All right. Siddharth Bhai?
My lord, Siddharth Bhai is 63, 30th of August 1962.
And Kerala Education?
Kerala Education, my lord, 25th of May 1958.
All right, we got the. Yes.
So this institution, my lord, was formed in 1938. Admittedly, Muslims, members of Muslim community had given land, etc., and nucleus fund. 1940, it was registered as society. After registration, out of 40 members, 10 members were taken with permission of minority community from non-minority community. So Mr. Sibbal and Dr. Dhawan have both argued on this, that you can have other members also. So I'm not getting into that. That became the reason to stop me from administering my institution. I went to Allahabad High Court. Allahabad High Court granted a stay. Immediately it was revoked in 1980, and then I had to approach this honorable court, and this question was framed by Justice Fazal Ali.
Factual sequence once again, just so that.
My lord, 1938, this society was formed informally. In 1940, society was registered under Societies Registration Act. I was extended with aid in the pre-constitution time. 1950 Constitution of India came into effect.
When was aid granted?
My lord, between 1940 to 50, I don't have exact date, my lord.
All right. Yes.
And thereafter, it was treated all along as minority institution till 1970. In 1971, my lord, 77, the administration stated in one line that it is not possible to recognize you as minority institution. One line. 1977, my lord, 13/1/1977. Again, 3/5/1978, I was told that we will not declare you minority, though it was being treated as minority.
What was the date in 77, you say?
13 of January 1977.
Yeah. Then repeated on?
3rd of May 1978.
Yes.
And 2nd of May 1980, finally, they said that your governing body is not limited to the scholars of Muslim minority. That's why I will not treat you as minority. Out of 11 members of governing body, I am told one was from non-minority or two. And that was the background, my lord. And till 70, my lord, till 80, when this last order was passed, I have already placed before your lordship 9 judgments were there. What is the meaning of administration? What is the meaning of minority? And what is the background of Article 30? So in a way, my lord, 1940 society registration is like MAO of AMU before 1920. MAO was also a society. So that is the background in which, when this entire argument took place, this was referred to, not like the submission that I see, that was all unrelated issue and somebody just wanted to refer it, and this is how the impression has been sought to be created in the written submission of Union of India, my lord. So that is the background. Now I am coming to, my lord, educational institution, my lord. I have created a table, my lord. I have created a 1E, my lord, if your lordship has. Just to run through fast, my lord.
Table at volume
One
one?
is before I go to table, my lord. Then, your lordship, I have shown TMA Pi and TMA Pi 779, my lord, volume 5A.
You were showing us something at 779, I think.
779, my lord.
What is that?
It is the question which was left open to be decided by the regular bench. 779, my lord. Question 3. Your lordship has it. This question need to be answered by not to be answered by this bench. It will be dealt with by regular bench. 779, volume 5A. Dr. Dhawan has argued this indicia question in DMA 5.
Whether it was conjunctive or disjunctive or.
So now my petition was finally disposed of without going into this question 3A, volume 1E, my lord, page 73. Volume 1E, my lord. Page 73. Page 73.
1A, right?
1E. E for
1E.
When it came before Honorable 2 judges, my lord, at page 74, my lord, this is the same petition, 5457. Writ petition 5457, 1981. May I read, my lord? Page 74. The petition above mentioned, along with other connected matters, being called for hearing before this court on 11th March 2003, upon pursuing the record of hearing counsel appearing for the parties, this court passes following order. The matters are covered by decision of Constitution Bench in writ petition TMA Pi and connected batch decided on 3rd of October 2002. All statutory enactments, orders, schemes, regulation will have to be brought in conformity with the decision of the Constitution Bench of this court in TMA Pi case decided on 31/10/2002, and as and when the problem arises, the same can be dealt with an appropriate forum and in appropriate proceeding, and the matter is over, my lord. So this is how my matter got closed. It's another thing that there are many petitions. Even today, Anjuman Rahmania has ad hoc principle for last 10 years, my lord, and it is working out of 53 sanctioned teachers' strength. They are working on 23, and 1,800 students, my lord. So that's another issue. So these statutory modifications have not taken place till now. Rather, there are different statutory provisions which have come taking away the right.
Right.
So,
What is
so
the
that-
effect? What is the effect of this order then?
the effect of the order, my lord, in my view, would be that whatever TMA Pi's ratio is, as per that ratio, all the regulations, all the rules relating to appointment, administration will have to be brought in conformity with the ratio. So that is that's what I can understand. But what is happening on the ground is altogether different. There are regulations saying that you will not appoint, private agencies will appoint. This is what has happened in Anjuman Rahmania's case. They have been, the entire right has been given to private agency that they will create, they will prepare a merit list, And from that merit list, you will have right to choose. So these things are going on. This, with my respectful submission, my lord, this is not in conformity with this order. And that is the ground for me approaching this on. 780. Yes, my lord. Coming to the second point, my lord, because this was an issue which was raised by the other side. That's why I thought appropriate to address, my lord, on this. I'll just conclude it quickly, my lord. Educational institution, my lord, of their choice. My lord, it is a very wide term which relates to setting up of an institution. That's what Siddharth Bhai has said. Setting up is important, my lord. Page 113, volume 5A. Setting up, with my respectful submission, can be related to the historical facts which has already been argued by Dr. Dhawan. How it was set it up in TMFI. So once you set up an institution, you exercise your choice. That could be a primary school and that could be a university. Now, after 1950, my lord, it becomes a fundamental right. Once it becomes fundamental right, then the entire system is obliged to give effect to that right to choice. Maybe that I may have to, I may be interested in establishing medical college. Medical college is not a university. I'll go get myself registered under Societies Registration Act. Myself registering into Societies Registration Act will not be termed as establishing an institution. It will be only a compliance of an statute which is existing to promote excellence, which has been argued. So this word setting up to establishment, the word used in 1950, I think, my lord, that needs little bit explanation on this. My lord, chart 4, page 4, volume 1E, my lord. I'll just quickly run through. It's only one page, my lord.
The table?
A table, my lord.
Where is that?
1E, page 4. This is all taken from Aziz Basha. On the left-hand side, my lord, Aziz Basha says, educational institutions are of very wide import and would include university also.
He is not opening.
Yes, sir. My lord, 1E.
One is both for brother Suryakant and me is not opening. We've got it displayed now.
Share it, I'll share it.
Yeah, thank you.
Good.
Right.
It's also on the
Yes, now
screen.
we've got it on the screen. You can just tell us, yeah,
Oh,
education.
page 4, my lord. This is both sides is Aziz Basha, my lord. I have given pagination. I'll not go there. just to save time, my lord. Educational institutions are of very wide import and would include a university also. That's what Aziz Basha says. Now, left-hand side, right-hand side, my lord. Before Constitution came into force, most universities were established by legislation. So it's all right. Not disputed, I am on the left-hand side, not disputed by the Union of India, and hence it may be accepted that a religious minority had right to establish a university under Article 31. So in Basha also, the stand is that, yes, you can do that. Then third, my lord, it is true that the nucleus of Aligarh Muslim University was the MAO college. And on the other side, my lord, if your lordship sees, conversion of that college into university was not, however, by Muslim minority. What was this conversion? Conversion was legislation. It took place by virtue of central legislation. Now I will come left side, my lord, once again. It may be that 1920 Act was passed as a result of efforts by Muslim minority. Right hand side, but that does not mean that the Aligarh Muslim University, when it came into being under 1920 Act, was established by university, by Muslim minority. Fifth, my lord, there was nothing in law then to prevent them, MAO or university foundation, from establishing university if they so desired without asking government to help them in the matter. But if they had brought into existence a university on their own, the degrees of that universities were not bound to be recognized by the government. That is the genesis, my lord. The entire thing falls back to recognition. In 1920, in 1950, Article 30, terminology is used, established. So that recognition becomes established. That's the interplay. How this was argued, my lord, this is also interesting. In Aziz Basha, when the matter came before your lordship, it was only in relation to administer. It is the Union of India that took a stand that, sorry, this university is not established. So the entire debate went in the line of established. Your lordship may have this for a moment, my lord, 3A. I just want to show that, my lord. 3A, my lord, page 7, my lord. 3A, page 7. This was not an issue of whether established or not established when Aziz Basha came here. 3A, my lord, page 7, my lord. May I read the last para? The petitions have been opposed on behalf of Union of India, and the main contention is that Aligarh Muslim University was established in 1920. So this is what they said. And establishment was not by Muslim minority, but the government of India by virtue of a statute, namely 1920 Act, and therefore the Muslim minority could not claim fundamental right to administer Aligarh Muslim University under Article 30. So this came during the argument from Union of India. Now this will become more clear, my lord, if your lordship comes to page 16, my lord. Placitum E16. In the middle, my lord, this is a small para of 5 lines. Page 16. The contention of the petitioner is that by these drastic amendment of 1965, Muslim minority was deprived of the right to administer Aligarh Muslim University, and this deprivation was violation of Article 30. So the issue was this, Placitum E. But Union of India says that, so that's why it becomes, entire debate becomes established. So I'm coming back to, my lord, that volume 1E, my lord, table 6, my lord, page 4 of that volume 1E, that table Roman 6 on the left hand side. There was nothing in 1920 to prevent Muslim minority, if it so chose to establish a university, it did so. If it did so, the degree of such a university was not bound to be recognized by the government. It could not insist that the degree granted by the university should be recognized by the government. Now on the right hand side, my lord, by Act of 1920, degrees were recognized by the government. Hence, an institution was brought into existence which could not be brought into existence by private individual. Then, my lord, 1920 Act is circumstance to show that the university came to be established in 1920 and not by Muslim community. Such recognition dependent upon the will of the government, generally expressed through a statute. This narration is for pre-independence time. Now, Article 30 is altogether in different shape, my lord. It is part of part 3. It's in part 3, where right to establish and administer is held to be absolute. Later on explained that regulatory things will apply, regulatory mechanism will apply. So that is the position post independence. There are 3 judgments at least to say that pre-independence, post independence doesn't matter. You will interpret fundamental right to give effect to and for the beneficial interest of the citizens. So I'm not going into that, my lord. Now, coming to the third point, my lord, recognition issue. Because Pasha says such recognition dependent upon the will of the government generally expressed through a statute. So the entire issue is recognition. About recognition, my lord, your lordship may have 5A76, page 76. Page 76. My lord. In between, my lord, in the middle of the page, my lord, from bottom, it's about 15-20 lines, my lord. Without recognition, lordships have got. Without recognition, therefore, the educational institutions established or to be established by minority communities cannot fulfill the real object of their choice, and the right under Article 30 cannot be effectively exercised. The right to establish educational institution of their choice, therefore, mean the right to establish real institutions which will effectively serve the need of their community and the scholars who resort to their educational institutions. There is no doubt, no such thing as fundamental right to recognition by the state, except upon terms that entail to surrender to the Constitution. Yes. Now, your lordship, this Kerala education, my lord, has been, your lordship may have 103, just to complete this, 103 in volume 5A itself. This is Siddharth Bhai, my lord.
Mr. Shamshad, can a minority institution say, I have a choice to establish a primary school, a secondary school, a higher secondary school, an intermediate college, a professional degree college? It's my choice. No difficulty. Can say that choice, according to you and the submissions on this side, is recognized by Article 30. Educational institutions of their choice. So it's across the spectrum. My question is this: can an institution say that when I establish, say, a university, you must necessarily recognize my right to confer degrees to that university without the provisions of an enabling statute?
No.
That I think we'll all be on the same page.
There are regulatory provisions.
There are regulatory provisions. So
those regulatory,
I'll set up an engineering college. But my engineering college should be recognized for conferment of degrees independent of the AICTE Act. No.
No,
Or that I'll establish a medical college and it
No.
should be. So if I have to establish a medical college,
I will fulfill the requirements. I will have this much, this big building. I will have these many teachers. These are the curriculums which I will accept. And if I have done all these, then I am entitled to be recognized within the system and carry on with the medical education.
now when is the university set up for the first time? When is the university established for the first time?
University is established for the first time, my lord. These are, there could be, because we are discussing AMU Act 1920. So pre-independence, position could be different. Post,
Would it be correct to say that the university owes its existence only to the AMU Act of 1920?
No,
Because the 1920 Act, there is no university at all.
no, my lord, there is university. The university is there. Basha accepts this, that I had right to establish university and it was there. But your degree will not be recognized within the system. So for,
But no, we are not on what your right was. Was there any university at all in existence pre-horse the 1920 Act? Or is it that the entire character of a university comes into being only under the 1920?
the requirement of recognition of that institution as university existed before 1920, I will say like this. And that is the requirement even today. For even if you want to establish medical college, you should have all these things. And once you assert this with the concerned institution, they have only this much indulgence, interference, that they will check it. They create a team and they go there, inspect whether it is there or not. If it is there, then you can't say you become general institution. It's minority institution. I have established it because I want to give some benefit to the community. It is not 100%, 50% I'll give it to the community because they are lagging behind. So that way, my lord's question, a recognized university in the system could be one thing. An institution which has everything which entitles it to become a university could be another thing. My choice, I can carry on with this without being recognized within the system. But I want to be recognized. So I approach the institutions. I approach UGC today. I approached the legislature.
But there's another issue that today you cannot set up an institution for the conferment of degrees which are not recognized. You can't say that, look,
Yes.
nobody can say that I will set up a university. You don't recognize my degrees. That the law doesn't permit. If you have to set up a university today, it has to be recognized within the fold of the governing
That
group.
way,
Otherwise, what will happen is, there's a reason for it, that students will take admission to a university, they'll pay valuable fees, they'll spend 3 years or 4 years of their life, at the end of it, get a degree which has no value.
my lord, that aspect, Dr.
Today,
Dhawan
nobody
has
can
argued
even
Professor
say-
Yaspal's case.
Right. Nobody can even say that I will establish a university today and I take the consequence of non-recognition.
I did not.
I'm good enough, my students will still come to me. Nobody can say that today also.
Yes, my lord. That's why I said that I may have everything which entitles me to claim a recognized university. I may be running that institution. But the moment I have to have my relevance within the system with the degree, then I will go to the authority. The authority could be any
So
statutory.
we got your point. I think the drift of the submission is that the conversion
Yes, ma'am.
of the status of MAO college into a university under the AMU Act was for the purpose of ensuring that the degrees would be recognized under law. And therefore, the Muslim minority itself was the proponent of this move to convert this into for the passing of the legislation, because you wanted the benefit of the degrees being recognized. Therefore, the act is only for the purpose of recognition. And therefore, you must look at the antecedent historical circumstances.
And in
I
that
think is the-
background, in the statute, my lord may have used the word established in the objectives, etc. That time, nobody knew what is going to be Article 30 in 1950.
Fair enough, that point.
And
yes.
that too.
Mr. Shamshad, should we close it at that?
Yes,
I think
one,
it gives
one,
about 45.
one point,
I
my
think
lord,
we can close now.
and Xavier's, my lord, just note down the pages. Volume 5A, 217, 243, 255,
Can you just say volume 5A, page?
217, Justice Reddy's opinion,
Yes,
243, Justice Khanna,
yes.
255, Justice Matthew, and again 259, and 287, Justice Beg. They all have emphasized how recognition is important. That's why this is, my lord, 9 judges, my lord. So that's how I conclude this point, my lord. As far as the group rights are concerned, my lord, there are various beneficial rights given to scheduled caste, scheduled tribe. Just take out that chart. OBCs. By statute, we create rights for women, physically disabled persons, victims of crime. They all get different benefits as group in different educational institutions as part of affirmative action.
There's similarly, minorities also have a group right, which is recognized by Article 2930.
And for that, my lord, Keshwananda Bharti, my lord, 1E. So, my lord, I have just made a chart of this.
Just give us the page and we'll be done.
That chart, my lord, volume 1E, my lord, page 5.
We'll have a look at it. Don't
I have given
Mr.
instance
Shamshad,
of about
basic proposition, I don't think you need to
five,
sit on that.
5 universities, which are tribal universities created in tribal areas for tribals. There is a university for OBCs and SCs. There is a university in Delhi by Delhi government for women. And all are state funded. Yes, I can understand in tribal universities, the other side may object, saying that the reservation is defined nationally, so that will apply. But in that 2006 Act, there is a provision that reservation can be increased. So that is very flexible. So once we can have these group universities,
Why not for the minorities?
why not to the minorities, my
Thank
lord?
you,
And
Mr. Shamshad. I think we
on
close
this
at that.
line, my lord, this Keshwananda Bharti 1E, page
Yes, just
78,
give
my
us
lord,
Page?
page 78. Page 78, my lord. 1E, this para 535A, this has given entire background how these minorities, this minorities' right was discussed, debated, committees was formed, and how it became so important. I will not read, my lord, it's a longish para, and it has said that is in the nature of basic feature. This is, yes. So, my lord, I just conclude, my lord, by saying that this, my lord, minority's choice, please don't make it exclusionary. Siddharth Bhai said that you will not interpret with a cutting down effect. My lord, Basha is a cutting down effect, which takes away para 8 of Siddharth Bhai says that you will not interpret with cutting down effect. And my lord, this 5A, page 87, Kerala Education also says that you will take into effect what is the impact of a particular interpretation. The impact is that admittedly an institution which was established by minority is being taken away. And what 50% only seats that one aspires to give it to their own community. That's the effect. Otherwise, what rule we are not following? Mr. Sibal has already addressed your lordship on this, that we follow everything. The effect is that certain seat can go there. That's the effect. And for that, your lordship, With greatest respect, Your Lordship will not give it cutting down effect. Your Lordship, my Lord Justice Sharma on that day asked Mr. Farasat, aid issue. Aid has become irrelevant after 2-3 judgments. I feel from the other side's argument also today that there is some undercurrent that aid is there, so I will take
That's
this.
well settled. You don't have to give up your minority status when you seek aid. Because today there's a recognition that without aid, no institution, minority, non-minority can exist. Therefore, merely by seeking aid or being granted aid, you don't lose your right to claim your minority status. That's now very well settled.
So Kerala and TMA, my Lord, 11 judges.
Thank you, Mr.
I am deeply obliged.
Thank you. Now we have got, I think, Mr. Mrinal Chakrabarti, Mr. Pulkit Agarwal, and Saib Mehdi Imam.
For information that these new icons.
So we'll call upon the other side now, I think. Yeah, I think we can call upon that side. Thank you, Mr. So, Mr. Attorney, you will start.
My apologies for not sharing my very brief note earlier, but I've shared it now. I am going to address the court a very narrow aspect of the matter. Picking up from the last threads about the competently established university, I would like to look at
Where is your note?
that
Where did you get it,
dimension.
Mr. Attorney?
No, I have received, I'm just reading it to live.
All right. We have just got the notes, so they will.
In my understanding, it's not a case which is emanated from a deprivation of an Article 30 right. There's somebody keen to establish an institution of their choice, and that came to be declined, and therefore we need to reopen Ashish Basha for the purpose of understanding, establish and administer. If that is not so, we're only looking at Ashish Basha, whether it is reading of Ashish Basha would have any future implication. It could have a future implication only if there had been deprivation in a current context. If that is not so, Ashish Basha is a standalone case. It doesn't have any future implication at all.
Should we read the note so that we'll have your?
May I just quickly read my note?
Yes, let's read
And
it.
then pick up some threads out of the note.
Sure.
The jurisprudence of Article 30, besides the minority feature, has looked at two other aspects of the provision, namely educational institution and choice regarding such educational institution. Having regard to the constitutional protection and guarantee underlying Article 30, Supreme Court has not read any limitations on the scope of the choice of educational institution. Thus, we find that educational institutions purporting to import secular education in all subjects have been read into the choice aspect of Article 30. It can be further stated that it cannot be the concern or authority of the state to inquire into how the choice of educational institutions facilitate or serve the interests and needs of a minority community. Protection, promotion, or preservation of identity of minority section is the philosophy underlying Article 30. However, Article 30 is an enabling provision as well. The further key to understanding Article 30 lies in exploring the right to establish and administer part of the provision. In order that the educational institution of a particular character or class, I mark that aspect of it, of a particular character or class could be established by any person, minority or otherwise. The first prerequisite would be the legal competence or authority to establish that class of institution. In the absence of a legal competence to establish a given class of institution, the question of availing all attendant rights and claims in relation to Article 30 cannot arise. Under the constitutional
Can we just
scheme,
repeat that?
the power or
Mr. Attorney, just go back to item 3. I didn't. follow.
item,
Item
Three.
two and two,
Two and-
last part
yeah.
of 2 and 3.
Can we
Paragraph
just, can we reread 2 just a little slowly?
Para two?
Because I'm also, yeah.
however, Article 30 is an enabling provision as well. The further
What do
key
you
to
mean by enabling provision? What do you mean by enabling provision?
Are you when you say enabling, are you referring to the choice of the minority? Then
You have already dealt with it in Article 1,
You
paragraph
see,
1.
you see, it's not an enabling provision in the sense in which we conventionally
the
call
choice,
enabling.
the choice part of it is
Because
enabling.
enabling provision is like Article 15,
That's right.
where,
The-
you know, where you have the choice to make a provision. 30 is not enabling insofar as the state is concerned. It's an obligation on the state to recognize the
It
choice.
enable the, I put it, enable the minority, the choice part of it.
So long
acquires
as
the
you
higher
say it's
dimension.
enabling provision in relation to conferring a choice on minorities, it's,
That's right. That's what I went to.
it can't be that I as a state can either decide to
I'm
grant or
talking
deny
about
you
the
that
state.
status.
I'm not talking, I'm
Right.
talking about a minority.
Therefore, the words as well is little, may not be appropriate, if I can use, if
Why
I'm
I've used it
permitted to
little,
use that word.
deliberately, in the sense that the choice part of it is available to every citizen.
Yes.
But the higher status is given to a minority. Therefore, I say it enables them to reach a level beyond the other common consideration. That's how you put it. So paragraph 3. In the absence of a legal competence to establish a given class of institution,
Just read the second.
question is, so, then I go to
Sir,
paragraph
sorry.
4 and
A
5.
second, can we go back to your second sentence of para 2?
Yes. In order that an educational institution of a particular character or a class could be established by any person, minority or otherwise, the first prerequisite would be the legal competence or authority to establish that class of institution. As we go further, I will give further
Right.
explanations about it.
Go ahead.
Right. So then as I go to para 4. Under the constitutional scheme, the power, competence, right to establish educational institution can be located only under an authority granted by a competent legislation. For instance, entry 25 talks about education. Then entry 14 list 2 talks about agricultural education. Similarly, entry 64 talks about institutions of scientific, technical education and are treated as institutions of national importance.
There is list 1. Huh?
That's right. Then prior to the Constitution, schools, colleges, other teaching institutions were established by societies or trusts by reason of enabling authority granted under the Societies Registration Act 1860 or the trust law to act towards the promotion of literature, science, fine arts, and for the diffusion of useful knowledge. Educational institutions such as schools and colleges are tools and instrumentalities in the pursuit and promotion of such activities. In other words, the competence to establish educational institutions of the above class towards imparting knowledge on the above mentioned fields of study was made available under the said legislations. I'm talking about the competence. Now, paragraph 5. Prior to the Constitution, prior to the Constitution, there was no other legislation that conferred competence on any set of persons to establish a university as such. There was no legislation that conferred competence to establish universities. In the absence of a law conferring or granting competence to establish a defined class of institutions, namely a university, the question of establishing a university did not arise. The Aligarh Muslim University is a product of a standalone legislation enacted by the then existing provincial legislature. The antecedent events, namely the establishment of Mohammedan Anglo-Oriental College, sought to be connected with the coming into being of the Aligarh Muslim University, cannot be said to be any part of the competence to establish the university as such. The Mohammedan Anglo-Oriental College was set up by the Muslim community, deriving its competence granted under the enabling provisions of the Societies Registration Act. That legal competence to set up educational institutions such as a school or a college cannot be extended to legal competence to set up a university. In other words, the power to establish a given class of educational institution must be granted under a statute. Prior to the Constitution, there was no power or competence available under any legislation either to establish a university or to convert a school or a college into a university. Consequently, the community of persons who had set up the Mohammedan Anglo-Oriental College did not have the competence to establish a university, and Aligarh Muslim University was not established by them in the above legal sense and understanding. Establishment of a college is different from establishing a university, and the one does not and did not merge into the other. Ashish Basha rightly understands this position and rightly did it hold, since the university was not established by the Muslim minority, it did not have the right to administer it. Then, in order, therefore, that after the coming into force of the Constitution, a minority community can claim the protection of under Article 30, it must first have the legal competence to establish a particular class of institution. The Societies Registration Act, like the law relating to trust, continue to be part of an enabling legal framework, by reason of which schools and colleges can be established. There must therefore exist a similar enabling legislation that either enables or facilitates or grants competence to establish a university. The scheme of the University Grants Commission Act, to the extent it regulates all matters relating to universities, including deemed universities, is comparable to such an enabling law. In the absence of a competence or authority granted or conferred under a law to establish a university, no person, whether belonging to a minority community or otherwise, can establish a university. The words educational institutions of their choice cannot be construed by itself, conferring an authority to establish any class of institution, regardless of a legal competence to do so. The authority to establish a given class of institution must first precede and be traceable to and be located under an enabling statute. The choice aspect of educational institutions will then follow. Within the scope of an enabling legal framework, which may confer the authority to establish institutions, the choice aspect will be unfettered and free. And this is the essence of Article 30. So neither prior to the Constitution nor under the Constitution, a minority community was clothed with the authority to establish a university. In this legal sense, no infirmity can be attributed to Ashish Basha. The unfettered freedom to establish educational institutions of their choice does not extend to the grant of exemption from the obligation to abide by other constitutional demands and requirements. For example, the obligation to honor provisions relating to reservations or matters relating to regulations of appointments of teaching and non-teaching staff, etc., and including general regulation relating to standards and quality of education. The choice aspect of institution does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions, which are themselves as important as the choice, as long as the state does not impinge on the choice and which the state cannot. Article 30 is intact. The claim raised that Ashish Basha has wrongly interpreted the words establish and administer is misconceived. The question is not only of disjunctive or conjunctive reading. The fundamental question is one of the competence or the authority to set up an university. That being so, there is no warrant or need for reconsidering Ashish Basha, as it has no application to any post-constitutional institution, including an university. Therefore follows that for the purpose of Article 30, educational institutions need not necessarily include an university, and such an educational institution is subject to 11 regulatory regime. Therefore, the argument, I'll just conclude by a few more. If you go back to the history of granting degrees in England, from 13th century onwards, Oxford, Cambridge,
Tony,
all those
if
universities.
One accepts if one goes by the tenure of your arguments. Therefore, if a legislation is today made that school can be only established by this method, by registration under this act, then the right under Article 30 will also not be there. Suppose tomorrow, like the UGC Act, we have another legislation which says that the schools will be only established if you register under this particular act. Then that right will be also under Article 30, fundamental right under Article 30 will be also diluted to that extent. That choice will be then diluted.
Therefore, the whole question of a choice will have to be seen within an overarching legal framework or a constitutional framework. Constitution provides for an overarching framework. So statutes come in and say that this is what you will do. These are the kind of educational institutions that set up. That's why we're talking about a character, a class of an institution. So we did not, all the judgments prior to, for instance, even St. Stephen, the court did not go into the question, where is the legal competence to set up an institution? Does it flow from Article 30 by itself? Perhaps the answer would be no. Article 30 comes in at a point of time when the competence part of it is answered. If it is answered well, within the broader legal framework or constitutional framework, my choice is unfettered. But to
So
convert
according to, in the absence of an enabling legal framework, There is no choice within the meaning of Article 30.
No, and therefore, Article 30 premises,
If there
premise on the availability of a legal framework. Otherwise, it will be a vacuum. Article 30 envisages it because there's a history about setting up institutions, including universities.
Will it not make it then subservient to a statutory legislation?
No, that's why we were caught into a circular argument. We are trying, therefore, to come out of that. The argument, therefore, is my choice itself confer an authority to determine what will be the nature of a class of an institution. So, but in the absence of a defining framework, a legal framework, the choice will remain very abstract. It will have no social relevance and importance. Therefore, you can work wherever you are. You must work within the broader enabling legal or a constitutional framework. And within that, what I want to do, whether I want to have institution A, B, C, or D, and that is my choice. And how that choice will enable me to, exist as a minority is not a concern of state at all. That is where the unfettered freedom comes.
Pre-constitution, AMU was set up under the 1920 Act.
Logically.
Post-constitution, are there any universities which today have have recognition as minority institutions
No.
post-constitution?
No.
Something which is
No,
The whole idea of-
Just, sorry, interrupt.
Yes, I'm sorry.
Probably after the Minorities Education Act 2005 and 2010, it's possible. Because there
Let
is a
us look
specific-
into that law. Let us look into the law just briefly, and then probably that will answer some of the questions.
That is possible.
And that will probably also support what I'm trying to point out. I'm not saying for even
But your argument, if accepted, will mean any university set up by a.
I'll just pick up two provisions of the act. Yours kindly, it is PDF. Was putting some query. Yeah, I'm sorry.
2005 and then subsequent amendment in 2010
Yes.
with regard to minority education. Then it is possible to set up because once you get the status from that
Your Lordship.
under the said act, then obviously you can get it. But that was pointed out by Mr. Sybil during the course of argument.
I heard.
But
Yeah.
prior to that, prior to 2005, therefore it was, according to you, as far as university is concerned, they cannot be any minority university.
No, let me close my eyes to a statute like that. Let's suppose Parliament enacted a different law, conferring an authority to set up universities on any citizen whatsoever. And then brought about limitations on that power to set up a university. The story would have been different. So therefore, to say that Article 30 by itself is a reservoir of a competence or a power to set up a university. We are not talking about Ashish Basha. We are not talking about a future implication of a deprivation in educational institution. Therefore, if we stray beyond that, then there are some problems.
your argument, if it is stretched, will apply to every educational institution.
That's true.
That according to your argument, it wouldn't then only apply to university. That unless there is an enabling legal framework, you cannot set up any educational institution in India. If your argument is right.
Yes,
You
yes.
can't set up even a primary school. Your argument will apply to a school as well.
That's true. That's what I'm saying. Before
So according
we
to
have
them,
today a
the
plethora of
Article 30
legislation.
right- The Article 30 right is contingent on an enabling provision of legislation, recognizing
There are,
that right in statutory terms.
let me say the enabling legislation may have two components. One, to enable, to set up number one, to regulate what you do. So the
Regulation, there's no difficulty.
many,
Regulation, there's no difficulty. Enabling regulation which says that, look, you have to have so many teachers, you must have so much of reservation, you must pay your salary, teachers' salaries at a rate which is prescribed by the union government. That you will get aid only if you fulfill these conditions of infrastructure. There's no difficulty about that. Problem about your argument is because once you say that your right under Article 30 is contingent on an enabling legal framework, that will apply to every right, every matter of choice under Article 30.
That's right. But then to say because it will apply to every citizen, then how do we locate Article 30, the importance of Article 30? Then we need to depart from that regular framework and say have something special for Article 30. My answer would be no. Therefore, the competence to set up a particular class of an institution is what we are trying to talk about. We're not talking about a university in the abstract. any class of an institution, you will have a legal competence because every attendant consequences will follow with a competent.
And does it make a difference whether the institution is set up by or under a statute?
I know it has created some.
Right? Because by a statute, you can possibly say, as in the case of AMU,
In Vice Degree College.
that, right, that it has
That's
been
right.
set up by this statute. What about a university or an institution? We forget the university issue. You set up an institution under a statute.
Right, I'll just give you examples. There are some states which are called universities legislation. Karnataka, Kerala, they have this university legislation. Under that act, you can set up a university. Or there are private universities. I want to set up a university, but I can't do on my own volition. There are any number of private universities. The state legislature intervenes. So in the absence of an intervention by a legislature, even private universities cannot come up. Therefore, the competence part of it, either a legislature intervenes or a law intervenes and provides you and gives you that competence. It's very important. Therefore, prior to 1920 Act is where the legislature intervenes, I am setting up a university.
But does the fact that the legislature, you rightly gave the example of, say, legislation in the states, which has the standalone legislation, providing for the establishment of a particular university in a state. Private universities have been established in Tamil Nadu, for instance.
Any number of private.
Any number of states. Haryana. So many universities have been established under deeming legislation of the state governments. Now, does the fact that the university has been established by legislation of the state by itself amount to a denial of the right to claim minority status?
No, in a given case, I
Does
said,
the fact that the institution has been set up under a law amount to a denial of its right to claim minority status?
right.
If the answer is in the negative, then when do you say that, well, your minority status cannot exist?
May I put it the question?
Suppose there is a society. Suppose there's a society which is established by a minority A, whether it's Zoroastrians, Jain,
Right.
whether it's linguistic or religious minority. That minority then seeks to set up a university. A law is enacted by the state legislature providing for recognition as a university, that the university is set up. Now, the institution itself, the foundation is by a minority. The society is a minority society. The state legislation confers upon it the character of a university. Does that by in itself amount to a denial of the minority status? Two, suppose there's state legislation which allows for the setting up of universities, right? And a particular minority seeks to set up an institution within the purview of that legislation.
My answer.
Would that by itself lead to the denial of minority status?
My answer to that, now that there is a law occupying that field, Minority Educational Institutions Act, so that will address all these questions. And even that, let's only look at two provisions of the Act, Section 10.
Let's see the Act. Where is it?
It is volume 4A, PDF, the Act begins at PDF page 221. At page 223, solicitor's note on this act is fairly exhaustive. He will deal with it. But just want to point out, say that 10 and 10A. 10 begins with this, subject to the provisions.
Mr. Solicitor, sorry, Mr. Attorney, is there any university established minority institution, university established after 1950 till 2010?
No.
50 to 2010? No. There's none.
They're all schools, colleges. deemed universities under the UGC.
After 2010, obviously with the amendment made in the act,
There are. Therefore, section 10 talks about subject to the provisions contained in any other law for the time being in force. So this could be a law relating to regulation. This could be a law providing for certain requirements relating to establishment. It could be any law.
You're right, Jamshid, I was saying with 2G.
It will show me that. Is that? No. Can it be just shared? Some about this English position. It's a. You said it.
The right under Article 30, in certain areas, as our law has evolved, may well be conditional or contingent upon provisions of a regulatory statute. For instance, the right under Article 30 to establish and administer institutions of your choice, when you seek recognition, that recognition is contingent on provisions of regulatory statutes. When you seek the award of degrees, that right would be contingent on your complying with provisions of regulatory statutes. which are intended to define what the course of study should be, what should be the length or duration of the courses. When you seek to get aid from the state, there would be regulatory statutes which would define what is the nature of staff that you are going to engage. Will you engage people who have basic minimum qualifications? If you're a law school, that your staff must have passed the NET-SET examination, right? If you have to appoint a professor, that professor must have completed a doctoral degree. Years of experience for movement from, say, an assistant to an associate professor to professor, so on and so forth. Therefore, there can be no manner of doubt that the right under Article 30, the exercise of the right is contingent on compliance with regulatory provisions. Those regulatory provisions ensure that the true character of an institution as an institution of excellence, as our court has said repeatedly, is maintained. Second, that even minority institutions do not fall below a national standard in terms of the quality of the students which you admit. That they must all pass the CLAT exam for admission to law, or they must all pass the the NEET examination for admission to medicine, that they must pass the JEE for admission to the engineering degree courses. So regulatory statutes can define the minimum qualifications for the body of students, the staff, and the quality of the infrastructure which the institution must maintain in order to gain recognition. No difficulty. There is now the law has made that very, very clear. Minimum salaries, for instance, Frank Anthony Public School says that. But can the right to establish an institution itself be contingent on recognition by an enabling statute? That your argument seems to be overbroad.
I'm not saying recognition by
Because,
enabling.
because what you have said in para, the choice, para 9, the choice aspects of institutions does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions which are themselves as important as the choice. No difficulty. Regulatory provisions the state is entitled to make. I don't think any minority today can say that I am exempt from regulatory provisions. But can you say that, look, your right to establish yourself as a minority institution itself is contingent on enabling provisions in a law? Then you will be making a constitutional right subservient to a statute. The Constitution can do it. The Constitution can do it. We are not saying that the Constitution, if it has done it in a given case, that that provision is bad. But 30 doesn't do it.
I think I'm not trying to convey this proposition that recognition of setting up an institution is part of a regulatory and therefore it is subsumed within it. I don't propose to say that. What I'm saying is, before anybody can set up an institution, you must have some authority of law or a competence or a power available to you under some law. You can't say, I desire, therefore I set up.
Undoubtedly. For a moment, we concede that point.
Right.
But your argument that before you set up an institution, there must be an authority of law. Even if you want to set up a primary school, there has to be an authority of law.
That's right.
Some law in Uttar Pradesh, Maharashtra, Tamil Nadu, where you are allowed to set up.
So we call it.
But does that by itself detract from your right to establish a minority institution within the framework of the law?
No,
or to put it differently,
within the framework of the law, then the choice
Right.
is entirely there.
Right. So, or is it your argument that once there is a law, the moment you establish the institution under the law, you lose your right to claim minority status?
No, that's not what I will follow from what I'm saying. But saying once you have the authority.
Or that your right to claim minority status would be contingent on the law recognizing your right to claim minority status.
I
that
don't
I'm
think
not
that
sure
will
with.
follow from my submission. I'm only trying to narrow down a proposition that before you set up any institution of a particular class of institution, where will you derive your competence or authority? If that competent authority is lacking, you can't say independent of that competence, I still have a right to establish.
Fair enough.
That's all,
what
that's all what I'm trying to point out.
Right, fair
Therefore, Ashish Basha came with prior to the constitution, we don't have Article
But
30.
can the law say that because you do not have a right to establish an institution absent an enabling provision of law, and now I have an enabling provision of law, my enabling provision of law is contingent on your not claiming minority status. Can you do that? No. That will be violative of Article
That's not what I tried to, no, I'm not saying. So it's, therefore, in the context, in the narrow context of Ashish Basha, I think this is what probably one would look at. And I was trying to point out in England, although the universities came by a charter,
थोड़ा सा ऊपर
degree,
जाइए।
award, just.
ऊपर ऊपर नहीं, नीचे नीचे। थोड़ा सा नीचे।
So in a sense, therefore, even today, the University Grants Commission Act, it could have probably been a different legislation. It could have been a legislation conferring authority on any citizen, including minorities, to set up universities. But it did not do so. It is again enabling legislation that if you want to set up a university or to become a deemed university, you fall within this requirements regime. So this is, Volta universities operate under a royal charter. Some of these charters go back many centuries. The universities of Oxford and Cambridge received theirs in 13th century. In Scotland, so and so granted theirs in the 15th. A number of new universities were created following the two acts of parliament. In the 1992 Act is Higher Education Act, is more or less corresponding to the UGC Act. And then further Higher Education Act authorized the Privy Council to specify providers of higher education as competent to award and taught and research degrees. Therefore, the question of degree, we are talking about that. So who can confer a degree? Why can't the person establishing a college confer a degree? For that part, again, there are certain competences available to do something in the field of education.
Right. You've got the point. Thank you, Mr. Edwin.
Right.
Thank you.
May I add something?
At the in rejoinder, Mr.
Para 22, 92, even if regulations are invasive, they will fall violative of Article 30. For example, in St. Xavier's,
Head of the institution. I'll give you a classical example. Our court has held that you have an unfettered right to appoint the head of the institution,
yes,
right? No law can say that the head will be chosen by a panel consisting of, say, the vice chancellor, a professor nominated by the vice chancellor.
right.
That is clearly violative of Article
even
30.
regulations cannot be invasive. Lily
That's what
Korean
I'm
says
saying.
you dismiss somebody, you can't say you require the permission of the vice chancellor.
So for
Struck
instance,
down.
I'll give you an example. See Section 5, there's an act in Maharashtra called the Maharashtra Educational Institutions Conditions of Service Regulation Act. Section 5 says that the right to appoint a head and any any other two teachers is exclusively given to minority institutions. Because our court has said, head, you cannot say that I'll impose the head on you. There's an unfettered right to appoint the head. The vice chancellor can't say that I will, vice chancellor of a university which is, to which that institution is affiliated. Vice chancellor cannot say that, well, I will constitute a committee to appoint your head.
Quite
Our judgments have consistently held that head you have to appoint because the head of the institution determines the character of the institution.
Well, that's the point I was making.
Yeah.
That
Yes,
Vice
Mr.
Degree
Solicitor.
College reference, you'll just make a note of that about by or under. It has an exhaustive
Which one?
Vice Degree College.
Vice
The
degree.
1976
Justice Bhagwati's judgment. No?
It is perhaps it
Yeah,
is.
Justice Bhagwati's.
Which judgment? It is the Vice Degree College. Lakshmi Narayan was the Executive Committee of Vice Degree College.
Where-
Vice,
that's-
yes.
that's-
Vast degree. It's there in our complaint.
Is that a compilation? Yes, like this.
Write down certain problems, make them invasive.
It is Vice Degree College.
That
Yes.
is vice degree.
Vice degree.
It's there in our.
Yes, Mr. Solicitor General.
Perhaps attorney wanted to say
fully agree with Mr. Dhawan that if regulation is invasive, which denies right under Article 30, the regulation would be bad. There is no quarrel on that. But I am taking your lordships to a different point of view.
Yes.
Lord, your lordships are examining the law laid down in Aziz Basha, where
Yes.
Aziz Basha, my lord, examines the law which is enacted by the Imperial Parliament 103 years from today. We are, my lord, traveling back to it's 2020. We are in 2024. Lord, Aziz Basha will have to be understood in the context of the historical background in which Act of 20 was passed and historical background in which Aziz Basha was decided. Because my respectful submission is, Aziz Basha does not lay down a law of any universal application, nor does it lay down any ratio which the petitioners have understood.
Yes.
The petitioner's main argument was that Aziz Basha lays down that once you are established by an act of competent legislature, you can never become a minority institution. And the logic behind their submission is, and rightly so, if that is the ratio, but it is not, that now UGC Act requires that a university can be incorporated only by an act of parliament or competent legislature, and therefore there can be no minority institution, a minority university. That is not the ratio of Aziz Basha.
Yes.
So there was a particular regime in place during which, my lord, this movement started of establishing universities. That is somewhere in or before 1920. There were educational institutions either recognized through an act of the imperial legislature or otherwise. There were several universities, several institutions which had no blessings, Lord, of the imperial legislature. Lord, there were simultaneous two streams which were going on. One was, and we may not forget, my lord, 20s were the years where the freedom struggle was at its peak. One stream was that no, we will have our own university and we will not depend upon the British government's legislative competence or legislative power. The nationalists, my lord, they are historically called the nationalists. Without meaning any disrespect to the other group, that's how they are, my lord, described. Second was that no,
Yeah.
we must have an act of the imperial legislature so that the degrees are recognized where in the employment of crown, degrees of non-registered universities were also recognized, but not in the services of the British government. and not, of course, outside the country.
Yes.
So having more than one options and several, in fact, the majority, like my lord, Vishwa Bharati University, Shantiniketan. Shantiniketan was an institution. It had no blessings of the British government. It became university after UGC. And it was granting degrees, and their degrees were valuable. IIT Roorkee was an institution without any imperial legislation. You had that option.
When was IIT Roorkee set up actually?
1857. The name was different, Thomson College of Engineering, but 1857. Thereafter, in somewhere in 30s, it became IIT Roorkee, but remained unaffiliated. My lord, what I'll ultimately, my lord, I'll just say the end first and then take your lordships to the historical background. There were two simultaneous streams going on. I'm sorry. My lord, those who were in favor of, so far as this university is concerned, those who were in favor of accepting the conditions imposed by the British for the purpose of passing an act and making you an university. And the second, that no, we will continue with our minority Muslim status. We will not succumb to the British. We don't wish, because Britishers were saying that if you want a university status, you will have to give up some of your minority status. It would be a kind of neutral or a kind of a secular network which we will provide.
Not just minority status, but your cultural status as well.
My lord,
Be a non-minority cultural status which you are claiming.
my lord, that I'll show. My lord, those who were in favor of, my lord, having a university called Aligarh Muslim University under an act of imperial legislation, my lord, provided for that, my lord, and an act was passed where they surrendered many of their rights. And those who were confirmed, who were very sure that no, we will not, it would be an Islamic institution, they in 1920 from the premises of Aligarh Muslim University declared Jamia Millia Islamia. Jamia means university in Urdu, Millia means national, and Islamia means Islamic. They continued their status as minority institution the way they wanted without surrendering anything, and they were registered after the UGC Act came into my lord force. They were recognized. I'll take your lordship through that. Therefore, my lord, the ratio in Bhasha is that at a time where there were no fundamental rights, there was no Article 30, you had a choice of either not surrendering your rights or surrendering your rights and get an act of parliament, imperial parliament. You chose to surrender, and therefore it was established when it was passed by imperial legislation. And in 1920, there was no Article 30. So it was a voluntary surrender. Today, I cannot be asked to surrender my fundamental rights. But Britishers did, and they could. And everything is documented. And documents are on record from the beginning. What I have done, my lord, I was told my learned senior Mr. Singhvi's, Mr. Sibbal's objection that I have placed some new documents on record. They are, my lord, acts of constituting or incorporating several universities. I'm not going to read them, but I don't wish to be accused of suppressing something, my lord, the way they did. They placed on record, my lord, 3rd September 1965 debates without placing 2nd September. I have placed everything. I'm not going to read them. Now, please see, my lord, my note 2F. And, my lord, kindly examine Aziz Basha in this context, my lord. not 2F, my lord, page 1. I'm sorry, volume 2F, page 1. This was the regime in place where 1920 Act was passed.
Just one minute.
Volume.
This is Roman 2.
My lord, sorry, my lord. Roman 2F, but I'm sorry, my lord, I stand corrected. I should have
It's the last one.
said Roman.
Last one.
Will, my lord, with your lordship's permission, we'll change it to 2B1, my lord. I think it was 2B, it should have been 2B1.
But 2F, it should be numerical 2.
Done by someone else. But anyway, I'm not. But does your lordship? I'm sorry.
Vishwa Bharati came before UGC.
Much before. Vishwa Bharati University. Shanti Niketan, obviously.
Niketan was
much
there.
before, but
But
I just.
Vishwa Bharati University came sometime in 1951,
No, it was by an act of Indian Parliament.
Indian Parliament.
Yes, sir, your lordships are right. I stand corrected.
You said after UGC Act.
No, not. It was before that. I stand corrected. I have, my lord, that year also and the act also. Shanti Niketan, of course, my lord, was started by father of Rabindranath Tagore, but expanded and Lord, it reached its glory during the period of Rabindranath Tagore.
And we'll also sort of trace, I mean, those universities are not in question before us, so therefore we are not at all going to be commenting on them.
Yes.
But institutions which did get minority status, what was the course which they followed? What was the path which they followed? And you may want to make a distinction with AMU if you are making, that's your line of argument.
Lord, that the question of minority status came only after the constitution came in.
Right.
Lord, I have not weaved that also.
All right, we'll see how that.
But Lord, we would be doing injustice to Aziz Basha unless we read it in the dehorse the context and the regime it was available. Because just, my lord, this cannot be an argument, I am aware. But, my lord, just out of curiosity, I just examined. Lord, Aziz Basha is 65 judgment, 1968 judgment. 1968 judgment. The honorable judges, this is not an argument, and please don't take this as an argument, must be around 20, my lord, when 1920 Act was passed. Their age. They must be aware of this history, especially the author of the judgment. He was from Uttar Pradesh. Because this is the background. This was, my lord, a very hotly debated issue in the country. This was a part of Khilafat movement. Ali brothers, my lord, who separated and made Jamia Millia Islamia.
He was one of the few remaining ICS officers. He was
possibly the only Chief Justice without any legal background.
He was an ICS officer.
He was an ICS officer.
Mr. Dr. Lavan, right? Mr. Justice
Yes.
The advocates were in the majority and the ICS officers were in a minority. Very interesting about Golaknath.
That,
All of them were in the minority.
this is interesting. I did not know that. But possibly Justice Vanchu was the only Chief Justice who was ITF, who was not having a kind of formal legal background.
Justice A.K. Sarkar, perhaps.
Lord, please come to Lord, Roman 2F, page number 1. There is a chart, my lord, we have prepared. Lord, 1813, I'll just quickly go through what is, my lord, relevant for the purpose of completeness. But my lord, this, we will have to keep this in mind while reading Aziz Basha, my lord. It does not say what the other side apprehends. The Charter of 1813 of British Crown allocated funds for education in British India, leading to the establishment of institutions like Hindu College in Calcutta in 1817. Charter of 1813 read as under. My lord, I may skip that, only, my lord, see the highlighted part. Rest, my lord, I have put it for completeness. Provision for schools, public lectures, or other literary institutions for the benefit of natives. We were natives, my lord, we were subjects. To be regulated by the Governor General in Council, subject to control of the board, but appointment of two offices therein to the made by the local government. Then, my lord, next date, 1817 and 1818. Hindu College established in Calcutta in 1817, and the Sri Rampur College is established in 1818 by William Carey, Joshua so-and-so, and William Ward. Then 1854, an education policy of British India came in the form of the Woods Dispatch of 1854, officially known as Dispatch of Indian Education. It was seminal educational policy document issued in 1854 by Sir Charles Wood, the President of the Board of Control for India. It marked a significant step in the development of modern education system in India. The dispatch advocated for the establishment of universities in major cities and improvements in schools. It specifically provided as under. This dispatch is discussed during communications between those who were requesting for Aligarh to be declared a university through an act of imperial legislature, and, my lord, the British Crown, through, my lord, the officer of the British Crown. We now proceed to sketch out the general scheme of the measures which we propose to adopt. We have endeavored to avail ourselves of the knowledge which has been gained from the various experiments which have been made in different parts of India for the encouragement of education, and we hope by the more general adoption of those plans which have been carried into successful execution in particular districts, as well as by the introduction of other measures which appear to be wanting, to establish such a system as will prove generally applicable throughout India, and thus to impart to the educational efforts of our different presidencies a greater degree of uniformity and method than at present exist. Lord, para 24, only underline part may be read, my lord. And the I'm sorry, my lord, I'll just read the rapid spread of a liberal education amongst the natives of India. Since that time, the high attainment shown by the native candidates for government scholarships and by native students in private institutions, the success of medical colleges and the requirements of an increasing European and Anglo-Indian population have led us to the conclusion that the time has now arrived for the establishment of universities in India, which may encourage a regular and liberal course of education by conferring academical degrees as evidence of attainment in the different branches of art and science, and by adding marks of honor for those who may desire to complete for honorary distinction. The function of the universities will be to confer degrees upon such persons as, having been entered as candidates according to the rules which may be fixed in this respect, and having produced from any of the affiliated institutions, my lord, please mark this. My lord, this MAO remained an affiliated institution to the then Allahabad University, which was, my lord, created by an act of imperial legislature. I'll come to that. And today also it continues, my lord. In this respect, and having produced, which will be enumerated on the foundation of the universities, or be from time to time added to them by government, certificates of conduct of having perused a regular course of study for a given time, shall have also passed at the universities such examination as may be required of them. Your lordships can, my lord, consider skipping the rest. Then 28. The examination for degrees will not include any subjects connected with religious belief, and the affiliated institutions will be under the management of persons of every variety of religious persuasion. This was the policy document which mandated this. Either you accept it if you want an act, or you don't accept it, as it would come a lot later. As in England, various institutions in immediate connection with the Church of England, the Presbyterian College of so-and-so, 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 is empowered to receive certificates for degrees. So in India, institutions conducted by all denominations of Christians, Hindus, Mohammedans, Parsis, Sikhs, Buddhists, Jains, or any other religious persuasions may be affiliated to the universities if they are found to afford the requisite course of study and can be depended upon for the certificates of conduct which will be required. My lord, St. Stephen's continued as an institution with minority status, with predominant Christian attributes, affiliated with Delhi University. I'll come to that. Other branches of useful learning may suggest themselves to you, in which it might be advisable that lectures should be read and special degrees given, and it would greatly encourage the cultivation of vernacular languages of India, that professorships should be founded for those languages, and perhaps also for Sanskrit, Arabic, and Persian. A knowledge of Sanskrit language, the root of the vernaculars of the greater part of India, is more especially necessary to those who are engaged in the work of composition in those languages, while Arabic, through Persian, is one of the component parts of Urdu language, which extends over so large a part of Hindustan and is, we are informed, capable of considerable development. The grammar of these languages and their application to the improvement of the spoken languages of the country are the points to which the attention of the professor should be mainly directed, and there will be an ample field for their labors unconnected with any instruction in the tenets of Hindu or Mohammedan religions. We should refuse to sanction any such teaching as directly opposed to the principle of religious neutrality to which we have always adhered. Because Sanskrit, Persian, Urdu, they were linked to religion in Lord, during those times. So to an extent, my lord, even today. The candidates for university degree will, as we have already explained, be supplied by colleges affiliated to the universities. These will comprise all such institutions as are capable of supplying a sufficiently high order of instruction in the different branches of art and science in which university degrees will be accorded. The Hindu, Hooghly, Dhaka, Kishugar, and Berhamporo government Anglo-vernacular colleges and the Sanskrit college, the Mohammedan madrasas, and the medical college in Bengal, the Elphinstone Institution, the Pune College, the Grant Medical College in Bombay, the Delhi, Agra, Banaras, Bareilly, and Thompson colleges in northwestern provinces, seminaries such as the Oriental Seminary in Calcutta, which have been established by highly educated natives, a class of places of instruction which we are glad to learn is daily increasing in number and efficiency. Those which, like the Parental Academy, are conducted by East Indians, Bishop's College, the German Assemblies Institution, Dr. Duff's College, the Baptist College at Serampore, and other institutions under the superintendence of different religious bodies and missionary societies. will at once supply a considerable number of educational institutions worthy of being affiliated to the universities. So you had a choice of continuing as a denominational institution affiliated with some university which would be under an act of the imperial legislature. Towards then, 1856-57. Towards the end of 1856, the British government in India passed draft bills for the establishment of the first 3 universities in India, namely University of Calcutta, Bombay, and Madras. These acts were passed in the early 1857 by the Imperial Legislative Council, a representative body empowered by the British Parliament to make laws for British India, which continued till 1947. Lord, why I say British India, some of the part of present day India was not in British India. For example, Hyderabad was not, it was a charter of the Nizam, my lord, under which a college was established. Then 1860, Act number so-and-so of 1860 passed by the Imperial Legislative Council expanded the powers of the above referred 3 universities to grant degrees. Lord, I may not read, my lord, that part. It merely says that now you are entitled to confer degrees. Every university, whether recognized by the Imperial Parliament or not, were conferring degrees. Degrees had values, but they were not entitled to have employment in the British Crown services. Now, 1882, Punjab University was established by Punjab University Act 1882, again imperial legislature. Then Allahabad University was established by the Allahabad University Act 1887. Then 1902, the report of the Indian Universities Commission was published. The said report with regard to MAO specifically noted as under, because this, my lord, MAO was an institution, a Muslim institution functioning and, my lord, affiliated with Allahabad University. In connection with MAO College at Aligarh, proposals have been put forward from time to time for the creation of a Mohammedan university. It does not appear that these proposals have received the support which would be necessary to give the scheme a practical character. And even if its resources adequate to the formation of a complete university were forthcoming, it is for the government to decide as to the expediency of creating a denominational university. There was no Article 30. There was no fundamental right. The government can decide whether there should be a denominational university or not. In the present circumstances of India, we hold that while no obstacle should be placed in the way of denominational colleges, it is important to maintain undenominational character of the universities. Taking clue from the Woods Dispatch, the British policy continued. And that was the policy, my lord, in 1902. Then, my lord, 1904, the Indian Universities Act was passed. This was an umbrella act which repealed other acts and brought within its purview above referred 5 universities, my lord, Calcutta, Bombay, Madras, Punjab, and Allahabad. It also reconstituted the governing bodies of the universities and gave statutory recognition to the syndicates. Now, my lord, comes the moment where, my lord, this would be relevant for the historical perspective which I'll narrate. In 1915, 1st October 1915, Banaras Hindu University Act is passed by Imperial Legislative Council, leading to the establishment of the BHU. Now please see, my lord, para 4. The above history clearly depicts that British parliamentary policy was to confer the status of university only when the nature of the university is non-denominational, what we call secular, my lord, broadly in the present context. And second, provides for prominent governmental control. But please note, it's not governmental regulation, governmental control. This was an era in which establishment of any university which had advantages in the form of funds, value of degrees, I say value, not recognition, value of degrees, possibility of employment with imperial government by its alumni, etc., needed a legislative enactment by the British legislature fulfilling the above referred two criteria. In all cases where universities were established by way of an act of imperial legislature, it ensured both the above referred two criteria are met. The presence of both above criteria obviously changed and resulted in alteration of character of any institution, even if such institution was, before the enactment of imperial legislature making it an university, of a denominational or religious character. Such universities which were established by an act of imperial legislature were national, open, and secular centers of learning. The following is the list of universities established by imperial legislature before the constitution came into force. My lord, I have already mentioned Calcutta, Bombay, Madras, Punjab University, my lord, in Lahore, then University of Mysore, Banaras Hindu University, Patna University, Aligarh Muslim University, University of Lucknow, University of Dhaka, Delhi University, Nagpur University, Andhra University, Agra University, now my lord known as Dr. Bhimrao Ambedkar University, Annamalai University. My lord, Annamalai University, please note here something would turn on that, my lord. There was a question that one who founds, founding moment also has its value. No, there are two types of legislations. One, legislation which incorporates the university, and second, the legislation which, while incorporating the university, recognizing the founding fact also. In Annamalai, the founding fact is also recognized. I'll show that. That's a separate point. Then University of Sangyu, Rajputana, Guwahati University, University of Kashmir, Karnataka University, Maharaja Sayajirao University of Baroda, etc. My lord, I'm sorry, my lord, I stand corrected. My lord, page, item number 20, my lord, there is a mistake. It was established, my lord, in 50. That is in 46, but my lord, second amendment was passed in 50. Nothing turns on that, just a factual correction, my lord. Then Savitribai Phule University, formerly known as University of Pune, and Gujarat University, 1950. The universities established by Indian efforts without succumbing to British conditions and retaining its independence. Now, my lord, I have said that there were people who were ready to accept this non-denominational character and British governmental control. But that was an era of nationalism. That was an era of freedom struggle at its peak. So there were people that, no, we will have institutions from our own resources, will not have governmental control, we will not depend upon the British government's imperial legislation. Well, that I have seen. It is submitted that prior to the UGC, in absence of any prohibitive framework stopping someone from establishing universities without a legislative act, it was wholly permissible for any group of persons to establish an institution and label it a university or a Vidyapit or Jamia and claim to be the university. Now, my lord, this is prohibited. UGC Act prohibits use of word university, and you cannot be a university unless you are recognized under section 2F or section D. At this juncture, it is necessary to demarcate the distinction between a pre-constitution university established and recognized by the legislature as opposed to a pre-constitution university not recognized and not recognized by the British government. It is submitted that at the relevant time, it was wholly permissible for the MAO college to establish a university. There was nothing which prevented MAO from establish a complete Muslim university by the same name or any other name if it so wished, without any enactment, with the only drawback that such university would not have been recognized by the British government. It is relevant to note that there was no Article 30 and no concept of minority also. My lord, pre-constitution, there was no concept of minority. There was a concept of Hindus, Muslims, Parsis, etc. There was no majority or minority during British regime. There is nothing that stopped the said institution from doing so, which would have maintained its independence and perhaps its minority character. A large number of pre-independence universities existed whose degrees were not recognized by the British government for appointment in services under the Crown, but nonetheless went on to become leading national institutions. They were getting jobs, my lord, in big industries in India. British Crown was not recognizing those degrees. A list of such pre-independence universities, please see. Lord, Osmania University. Nawab of Hyderabad, Nizam of Hyderabad established. Gujarat Vidyapit. Lord, this was, Vidyapit means university. The way Jamia means university, Vidyapit means university. This was established by Mahatma Gandhi in 1920 as a part of non-cooperation movement, that we will not go to the British Parliament, which, my lord, under now after coming into force of UGC, Government of India, my lord, in 63, give them the status of deemed to be university under section 3 of the UGC Act. Then Bihar Vidyapit, again, my lord, Mahatma Gandhi established this university. Basha says you had the option of doing this, but you surrendered everything. Now you cannot raise Article 30 issue. Lord, Bihar, then Kashi Vidyapit, now known as Mahatma Gandhi Kashi Vidyapit. Lord, again a product of non-cooperation movement, and your lordships would see at the right side, Uttar Pradesh State University Act was enacted, which recognized it as a university defined under the UGC Act. Then Jamia Millia Islamia. In case of MAO college, there were two groups completely hostile to each other on the question of further course of action. One group led by Mr. Shafi, kindly remember this name, in the parliamentary debates of the British Parliament, he would open the debate on behalf of the British. Mr. Shafi wanted an act of British legislature surrendering the rights of functioning as denominational institution. And the second group, led by Ali brothers, who supported Khilafat movement when Ottoman Caliph was deposed by the British as an anti-Islam act of British. The second group, Khilafat movement, they played a major role because the Caliph was attacked by the British. It was more a pro-Khalif movement than, my lord, freedom struggle movement, my lord. The second group strongly objected for any British enactment and insisted by any indigenous university retaining, insisted for, my lord, it should be, retaining denominational character. Upon passing of Aligarh Muslim University Act 1920 on 14th of September 1920, there was an uproar amongst the opposite group led by Ali brothers, who wanted to retain the minority character of MAO. This group therefore declared establishment of Jamia Millia Islamia from the campus of Aligarh Muslim University itself on 29th of October 2020, just few days thereafter. This is, my lord, 14 September 2020, and after, my lord, that Jamia is, my lord, declared. Jamia means university.
Mr. Solicitor, only one thing. This is not really like, a contemporary date or something that we can take notice of. Can you give us the source from where this has been prepared, actually? So
yeah, it will come.
If it was footnoted or something, or if you have got some report or some historical document from which this is taken, because then while writing the judgment, we'll have to study all those reports, etc.
It was there already on record when we filed the my lord, our documents first.
All right.
And, my lord, we will give the reference, my lord, a little later. Now kindly see, my lord.
Because, this is...
Your lordships are right, my lord. This is a court of record, my lord. Retain its character.
to look at basically what was the status. I mean, we want to read through with you on your submission, but later on you can, when you are developing your submissions,
Yes.
what was the status of AMU under the 1920 legislation? And we can look at what was the status as on the eve of the adoption of the Constitution. So what happened between 1920 and 25th of January 1950? Because after 26th of January 1950, there cannot be a change in status. Because if it is a minority institution as on 25th January 1950, then the right becomes absolute on the birth of the Constitution.
Correct.
So we will have to then see, and as Brother Suryakant was just saying a moment ago, 50 to 56 is a further window because UGC Act comes in 1956. But the first step is for us to see what happened in 1920, what was happening between 1920 and 1950.
Yes.
Right.
My immediate answer is, and I'll develop that, between 1920 and the Constitution coming into force, there is no change in the Act. 1920 remains as it is. The first amendment comes in 1951.
And second, is the 1920 legislation also consistent with recognizing the pre-existing history of AMU, namely the MAO college, that it was predominantly founded by minority? Or does the Act itself, the 1920 Act, result in the abrogation of any claim to minority status?
Once, that's why,
We will not call it minority status, because minority status has a certain connotation under the Constitution.
yes.
Does the 1920, if I'll change my language, does the 1920 Act have the consequence of abrogating its status as a denominational institution
Exactly.
governed by a religious minority?
Absolutely. And your lordships are right, absolutely right. That I will have
You
to
could
show,
not
and I
do
will.
that post-constitution because you can't ask for a surrender of constitutional rights or fundamental.
Cannot be, but I can't.
But
argue.
prior to the constitution, the regime was entirely different.
Yes, yes. My lord, that's my lord, why I am giving this history. My lord, the purpose of giving this history is this. Lord, my respectful reading of Aziz Basha is that Aziz Basha's ratio is that you had three options. A, remain a denominational institute, the way a part of you, Jamia Millia Islamia remain, or other institution remain. Denominational or other unrecognized institution. Unrecognized in the sense that without any.
As a matter of just curiosity, what was the path which then Jamia followed?
Jamia remained an institution, remained a university, and thereafter, my lord, after this National Commission Act came in 2004, they applied for being declared a minority institution, and it was so declared. It is
That matter is still pending.
still pending, my lord. Therefore, I'm not going beyond.
What you're arguing may have impact there also.
My lord,
May have impact.
my lord, I'm consciously, my lord, arguing only those parts which may not affect me here, but either way. Your lordships are right. My lords are absolutely right.
And I was a member of the bench which admitted the petition. Let me tell you, the government over there had also changed their stand on Jamia Millia Islamia, whether it is a minority institution or not.
Possible. But I'm not, Lord, I didn't appear, but your lordships are right, my lord. Possible. There is
Your
a,
distinction with Jamia for the purpose of this case may ultimately affect you in the Jamia case.
no, I'll be, my lord, conscious, my lord. Your lordships can write, my lord, or whatever.
Right. We
But
will not trench into an area which is the subject matter of
Of another litigation, because Jamia is not here, my lord, otherwise also.
Right.
But, my lord, the point I'm making is, Jamia is just an, my lord, illustration. There were several institutions.
So according to you, Jamia was born out of the desire to preserve the denominational status of a university.
Which was surrendered
In the case of MAO.
case of Aligarh. That I will show, and with pagination.
Let's go ahead.
But, my lord, I'm really tempted, my lord, to show to your lordships, my lord, the pre-constitution, I'm sorry. Lord, Ali Brothers writes a letter to Raja of Mahmudabad, my lord, who was on the other side, my lord, in favor of Aligarh University being established. That these people are sent in the service of God, not service of British Crown. And therefore, what you have done is disastrous, etc. But leave it at that. There were institutions during that pre-independence, independence struggle time, like ultimately became Vishwa Bharati, which had reputation, which used to grant degrees. Degrees were recognized, except in British Crown services. Please see, that list. I am not reading the entire list. At page 11, Delhi College. No law of British Parliament. It was affiliated with University of Delhi. I just give some examples without going into Scottish Church College, Kolkata, item number 6. Presently a minority college affiliated to the University of Calcutta. It continued as an institution, continued as a minority. St. Stephen's is a pre-constitution institution. It continued continued to be affiliated with Delhi University. Please come to page 13, Roorkee College of Engineering, page 13. 1847, Government of Northwestern Province established College of Engineering at Roorkee in 1847. In 1853, college was renamed as Thomson College of Civil Engineering, which got affiliated to Calcutta University in the year 1864 and later to Allahabad University in 1894. The college was incorporated into Roorkee University with a Roorkee University Act 1948 passed by provincial legislature. In the year 2002, the university was incorporated as Indian Institute of Technology, Roorkee, and was declared as institution of national importance. But during pre-constitution, it chose to continue as an institution without any imperial legislation backing it. Then, then St. Stephen's College, item number 16, founded in 1881 by Cambridge Mission in Delhi in conjunction with, your lordships have para 16, in conjunction with Society of Propagation for Gospel. The college became one of the 3 original constituent colleges of University of Delhi when it was established in 1922. Delhi University was established thereafter. The college existed. Thereafter, my lord, please see, my lord, 25, page 16, my lord, very eminent, my lord, college, but now, my lord, a university, Gurukul Kangri, I think somewhere in Haryana, Gurukul Kangri. Gurukul Kangri now is a deemed university, was founded on March 4, 1902 by Swami Shraddhanandji, became the deemed university after enactment of UGC Act in the year 1962. Then, my lords, may kindly skip and come to 30. Dakshin Bharatiya Hindi Prachar Samiti. This is a linguistic minority institution in South India. In Karnataka, this is a leading institute. Dakshin Bharatiya Hindi Prachar Sabha was established by Mahatma Gandhi with the sole aim of propagating Hindi in southern states. The institute got the status of being an institute of national importance in 1964 by Dakshin Bharat Hindi Prachar Sabha Act 1964. The act came into force thereafter, when Indian Parliament took it over. 33, Vishwa Bharati. Ravindranath, we say Tagore, it's also called Thakur, established an institution known as Vishwa Bharati at Shantiniketan, later established as a university and recognized as an institute of national importance with a Vishwa Bharati Act 1951. Lord, your lordships, I'll take your lordship through that. Lord, entry 63, that the central government has the power of declaring some of the institutions
As institutions
of all IIMs, IITs, etc. My lord, Vishwa Bharati is one of those, my lord. So, my lord, there were, my lord, I have given the illustrations. I am not reading, my lord, all the illustrations.
Where have you drawn this from, Mr.
Lord, this is from the public domain, my lord, from the
That from individual colleges' websites, or is there
Yes,
some
yes,
report from which
yes.
you have got this?
From the websites, individual colleges' websites. But the rest of them, my lord, I have given, my lord, the act, pagination, where would you, what your lordships find, my lord, in the document compilation, etc., from here onwards. Lord, kindly now come to page 22, my lord, para 11. And here your lordships would find, my lord, the pagination and reference, everything. The birth of Jamia and AMU, the backdrop of Aligarh.
Kalakshetra at state number 44.
I'm sorry, my lord.
State number 44, Kalakshetra, very famous institution.
Very, very, yes, my lord. But I was, my lord.
Rukmini Devi earned there in 1936.
Yes, my lord. My lord, Rukmani Devi Arundale established this. No, I didn't want to, but each, my lord, for a 43, Indian Statistical Institute. It's now an institution of national importance. Lord, there are several which eventually, my lord, went on to become institution of nation. Banaras Engineering College, my lord, 31.
Now 22 you want us to go to, right?
30, yes, my lord, page 22. Well, there are several which chose, and the choice which was available with MAO, that is what Basha says. Basha doesn't say that because you have become a university, now you cannot have a minority status. No.
What are the indicia? Later on, we'll again look at it. What are the indicia to indicate that when it was conferred with a university status, that it surrendered its minority status?
Yes.
The mere fact that it is converted, that it is given university status does not amount to a surrender of this
No,
minority
no,
status.
no.
Or denominational status prior to independence. We'll have to independently see whether by the 1920 Act, the denominational character of AMU was lost. You have given us that little thing about, the Khilafat movement and everything.
Yes, Lord, I have given three compartments. I have given the correspondence which is already on record to show that there was a correspondence between Britain and MAO College, that you will have to do this if you want an act to be passed. Second, the debates in the Imperial Parliament, where Mr. Safi introduces the bill and keeps on surrendering, my lord, the denominational character. And third is the act itself. The act as it stood in 1920.
So your argument is it's not the enactment itself, but prior to the enactment.
Exactly. And his lordship says that it is the fact that you have surrendered and act came into effect. Now you cannot claim minority status. And I'll show that finding. Lord, Basha was very cursorily read. Some patches here, some patches there. Lord, I want your lordships to read Basha, Lord, the way I would wish your lordships to examine.
We'll return after lunch.
Yes.
Yes, Mr. Selvan.
Wait, please. So kindly come to page 23 of Roman 2F. Lord, the submissions which I was reading. And here, my lord, I have given the references of the documents. So 22 is the birth of Jamia and AMU, the backdrop of Aligarh split. My lord, I have orally submitted, but
Yeah.
page 23, small ABCD.
Yes.
It must be noted that original vision of AMU, as envisaged by Sir Syed, was based strongly on loyalism to the British. But I have given footnotes, my lord, etc. The split in the Aligarh movement began after the government refused to grant it the power to affiliate colleges outside Aligarh. Even prior to this, the Ali brothers had made attempts to rid the college administration of pro-government influences. The divide had become worse when two camps formed over the government refusal to allow affiliating powers to the MAO college. This rejection, along with events such as annulment of partition of Bengal, was seen by Muhammad Ali as betrayal of Muslims. Those willing to accept the government's proposal were headed by Maulana Aftab Ahmad Khan, the loyalists. My lord, every historian, my lord, described them as the loyalists, and later Muhammad Shafi as a
Now,
follower
when,
of what he
Mr.
called.
Solicitor, when MAO, though it was called MAO College, was it basically a college or was it in the nature of college plus like a university, or is it purely a
It
college?
was a college affiliated to
Allahabad
Allahabad University, the way St. Stephen is today a college affiliated to Delhi
So
University.
MAO was by all accounts only a college.
It was a
basically.
college.
Only in the sense it was exclusively a college.
Tertiary education was given by the college, hence the degrees. Because we're concerned with tertiary education now, not secondary. Because sometimes one associates college with secondary information, education. But MAO had degrees and therefore it was involved in tertiary education as well. That's
So it
why
was
the
It
degree.
could have continued that way. Let us put it that
It
way
was a
without going
post high school institution.
That's right.
Well, yes, my lord, otherwise they needed no affiliation with the university. So it is not correct to say that MAO was giving degrees. MAO was affiliated
To
with
Allahabad.
Allahabad University, and Allahabad University used to give degrees.
Right.
So degrees of MAO was recognized by Allahabad University.
Right.
But
No, not degrees of MAO. Allahabad,
MAO,
the degree
the
was of
courses,
Allahabad.
I'm sorry, courses of MAO were recognized by Allahabad
It
University.
was an affiliating college of Allahabad.
Yes.
Yes.
There is no dispute on that.
We may not be very sure whether courses were recognized or not, but the fact of the matter is degrees were given by Allahabad.
Correct. As a follower of what he called the Anglo-Mohammedan school of politics, Mr. Shafi regarded his community's interests to be identical with those of the government and refused to take part in anything calculated in the slightest degree to injure British interests and to weaken the stability and permanence of British rule in India. But he is the one who introduced Aligarh, this 2020 Act. I'll show that from the debates. Those opposed were led by Ali brothers and Hasrat Mohani, who wanted both Muslim control of the university and the power of affiliation. Well, Hasrat Mohani was a member of the Constituent Assembly representing the Muslim League, one of the finest Urdu lyricists. The Ali brothers and their followers were also sympathetic to the Turkey and opposed the British actions against Turkey during the First World War. Furthermore, Muhammad Ali's influence over Aligarh student body was noted to cause great difficulties for MAO college principal, Dr. So-and-so. After the BHU Act was passed, those in favor, that was in 2015. 1950. I stand correct. 1915. After the BHU Act was passed, those in favor of accepting the government proposal began to mount pressure, stating that this made clear that any Muslim university would have to be on the same lines as BHU. At a vote held on the question of Muslim university associated on the question of accepting the government's terms, the loyalist one, that is pro-British one, that is volume 4D. I'm not reading, but this is the reference. This caused a formal split in the movement. In April 1917, the University Foundation Committee decided to accept the government's proposals without conditions, though Muhammad Ali remained opposed to the same. That is, my lord, Muhammad Ali is one of the Ali brothers, my lord. In 1920, it was agreed between the government and the Aligarh group to bring the university bill in the legislature. At around the same time, Gandhi ji, my lord, I'm sorry, it's a typo. It should be Gandhi ji, my lord. It's Gandhi instead of Gandhi. Kindly pardon me, my lord, and allow me to correct. Came into contact with Maulana Muhammad Ali and Hasrat Mohani and began promoting the Khilafat movement, because for Gandhi ji, it was, my lord, anti-British freedom struggle. So wherever, my lord, he could get support of anti-British sentiments, Mahatma Gandhi ji, my lord, used to take that. The rapid introduction of the AMU bill was seen to be an attempt to bring the Muslims to the government side in the face of anti-government sentiment among them during the non-cooperation movement. Subsequently, pro-Khilafat group wrote a letter to the university authorities asking them to stop receiving government aid. Well, there is a letter which is on record. From the beginning, I have placed that letter on record. Maulana Muhammad Ali called on the Aligarh trustees to participate in the non-cooperation movement. On October 12, 1920, Ali brothers and Mahatma Gandhi visited the college and asked it to stop accepting government aid. That was again a non-cooperation movement. At this meeting, even certain members of the Aligarh trustees resolved that if the college did not break ties with
These
the...
are all new facts, because now we're not looking at documents.
My lord,
We're,
4D...
we're looking at a very contentious part of our history. Loyalists, non-loyalists, etc. This is an imposition from a book, my lord.
Lord,
Let them stick to the pleadings.
my learned friend may not be aware, these documents 4D are placed by them. I am relying upon it.
No, definitely not.
And it is on record, my lord, since your lordships directed that this my lord, PDF file be kept ready. This is not something new I am placing on record.
At the same time, this is also what broadly the parameters I drew up when I was doing the Jammu and Kashmir judgment. That's something which is in a book, which is written by someone, however eminent the author,
Yes.
is after all secondary material.
Correct.
Official documents, official statutes.
Some of them are letters. Some of them are letters. They may not have read it.
Right.
Read
But
them.
something which is in a book, one sort of doesn't treat that as primary.
I rely upon the letters. The letters would not reflect these positions.
So what was the impact of the act, which is the second
Yes.
part which you are going to argue? Certainly, absolutely, that's beyond doubt, because you have an act of the legislature and we have to interpret the act,
Correct.
what the act does. But we have to be a little careful when we are dealing with underlying materials such as books, because books you will also find on both sides, depending on which side of the spectrum you are.
I leave it there. But I must say, this has been on record, placed by them. Now they're objecting
Fair
because
enough.
they have not
Look at
read it.
we
It
look
is
at
unfair.
it. We look at it. The evidentiary standard, of course, to a book which
Your
is
lordships
authored
may not take that into consideration, but the 4D is, my lord, filed on 10th of January 2024, the last day of, my lord, of filing of documents. Much before they started.
All right.
My lord, and my lord, with profound respect, I don't want to, it's a petty thing to argue before a 7-judge bench. They relied upon some portion from 4D.
4D was filed by them, my lord.
My lord, they relied upon them, but
Okay,
leave it at that. My lord,
let's see it.
I don't want to, my lord, reduce the level of this
We
debate.
are just entering a small caveat on so far as books are concerned, because
Yes.
books could be it's after all historical account. We have to
Yes.
also-
My lord, please come to J, my lord.
Yes.
During the said time, my lord, this is, my lord, a resolution which is on record. During the said time, the Aligarh students also began to participate actively in non-cooperation movement and passed a resolution on October 13, asking the university authorities to disaffiliate the college, failing which the students would employ all means to turn the college into a national organization under the control of the Central Khilafat Committee. The British and the Aligarh authorities asked alumni associations to persuade students to give up their demands, and the Shahranpur MAO Old Boys Association passed a resolution condemning the same. The party represented by Mr. Sibal the Old Boys Association. The leaders supporting the non-cooperation movement assured Aligarh students that MAO college would be turned into a national university and asked them to enroll in the new university. The Deoband Theological School issued a fatwa asking students to leave the MAO college and enroll in the proposed new national university. On October 27, the Aligarh Board of Trustees voted to direct Maulana Muhammad Ali and his supporters to vacate the hostel of MAO college and close the college for a month. Lord, the other group, Lord, that order is on record. Finally, Maulana Muhammad Ali and his followers vacated the college on October 29, 1920 and announced setting up of Jamia Millia Islamia. The intent of the new college was declared to be the purification of MAO college, and it was intended to counter the government influenced the university at Aligarh. Therefore, when the endeavor of Ali brothers did not succeed, they broke away to establish the Jamia Millia Islamia as a national Muslim university. The Jamia Millia Islamia was created expressly to be an independent institution which was not dependent on government grants or otherwise subject to government control, as opposed to the full government control support enjoyed by AMU. My lord, this is a letter written by Ali brothers to Raja of Mahmudabad. My lord, that letter is on record. I'm not reading it, but this is, my lord, I'm paraphrasing. I have paraphrased it. In fact,
Mr. Solicitor, there may be a problem in this line of argument. We assume for a moment that there were two factions, right? You had the loyalist faction, which was of the view that, you must dovetail your efforts in line with the then imperial government's efforts. There was then the other faction, which was, probably encouraged by Gandhiji as well, namely those who were supporting the Khilafat movement and non-cooperation. According to you, they broke away and they formed Jamia. Assuming that is so, the fact that the loyalist faction was more, in line with the British government then, does not deprive it of its minority character. The fact that they were in alignment with the views of the then imperial power does not make it any the less an institution founded by a minority. Founded by a minority does not mean that you have to be in opposition to the then government.
no,
Today, you may have a minority institution which is perfectly, on the side of the government on very important issues. That does not change its minority character.
I'm not on that. My lord, kindly allow me to say.
Therefore, this really to say that, there were two factions and one was, pro-loyalist, one was loyalist, one was with the British government, the other one was, with the nationalist movement.
It is
This
not,
will not have a bearing on whether it was
not-
it ceased to be a minority institution.
your lordships may, my lord, I would earnestly request to defer that conclusion for the time being. My lord, there is a reason why I am showing that.
We are not drawing a conclusion.
No,
We are
no,
just saying that this hypothesis is equally consistent with the fact that a minority institution may politically be aligned or may not be aligned with the
I'm
government.
not on that. I'm not on, my lord, because they were politically aligned to British, they were not minority. That's not my case. My lord, I am building up a case based upon the finding of fact recorded in Aziz Basha, that because of this you have surrendered your right. This is, my lord, they may find, my lord, these facts inconvenient, but they are on record. Your lordships may, at the end of my respectful submissions, may choose, my lord, to rely upon it, partly rely
The
upon it,
argument is that
or completely ignore it.
Your argument is that there was therefore a surrender of the minority state.
Yes, my lord, that's the finding. The finding is not that because you are a university, you can never be a minority institution the way they apprehend. That's not the finding. I am just trying to show how historically you surrendered what others did not. Others also had this option of surrendering their rights as a denominational institution and go before the government of the then crown and let that act be passed. But they continued their existence, dehorsed the government. No Article 30 was not in existence. You could have surrendered, you could have stuck to your ground. Vishwa Bharati stuck to its ground.
So they continued to award degrees which were not recognized by the
Yes,
government.
Yes, and subsequently, my lord, when the India became free, when UGC Act came, my lord, all these institutions which continued their denominational character or their independent character, they were recognized as either universities or deemed to be universities. I'll show the scheme of the Act. My lord, Section 3 says that if you have an institution, then in consultation with UGC, central government declare you to be deemed to be university. So they are now declared to be deemed to be university. But that option, this particular institution did not exercise, and therefore Aziz Basha says, you have surrendered. That is the ratio of Aziz Basha. So therefore, I'm respectfully, but
We got your point.
it won't take more time, Malone.
Yes.
Yeah, my intention is not that because they sided with British, don't trust them. That's not the idea. They had every right, my lord, to take their own political stand, and they took the political stand. Maybe that was a beneficial stand for the community, for the student, for the college. I do not know. I don't sit in judgment over them. Now, please see, my lord, 13. My lord, 13, your lordships can, my lord, skip. Now, kindly come to page 26, bottom. Now, my lord, post AMU developments.
Actually, 13, just read 13, Gandhiji's statement
Yes.
that supports your submission. Just
Yes.
read that statement by Gandhiji.
In fact, new institutions such as Jamia and Kashi Vidyapit were established specifically to provide education on nationalist lines, in contrast to AMU's loyalist approach. In a speech, Gandhi ji, my lord, I'm extremely sorry, my lord, my apologies. No, never do this. Mistake again. Himself noted the government controlled character if the university as follows. I have myself appealed to thousands of parents at which hardly a parent has objected to the proposition of leaving government controlled schools. I therefore take leave to think the parents of Aligarh boys are not less convinced than the others of the necessity of withdrawing their children from the schools and controlled by the schools and controlled by the government that has participated in betraying the Muslims in India and has wantonly humiliated the nation through its barbarous treatment of Punjab. Shall we not free
Jallianwala Bagh.
Jallianwala? This is near, historically, Jallianwala Bagh episode is being referred to by Mahatma Gandhi ji. That is 1919, my lord, Jallianwala Bagh. Shall we not free them, boys, from the curse of slavery which has made us crawl on our bellies? Surely they would not need government university degrees. Our existing religious and charitable Hindu and Muslim funds can support our education without even a week of self-denial. Personal view. Lord Para answer. Fifteen रहने
After Gandhiji's quotation, there is a reference to contemporary material. And this is what we are objecting to. Just see after that, it says, therefore, even contemporary material clearly suggests. Lord, this is very wayward, my lord.
When I would read Bhasha, I will read the
No,
act.
but we read Bhasha,
Yeah,
we read
yeah.
Bhasha.
It's not Bhasha,
Bhasha
it's
says
Bhasha.
surrender only in respect of property, nothing else.
Lord,
The word surrender, if used, my lord, is only in respect of property, nothing else.
Lord, if
Lord,
I would
I
have done this,
understand.
he would have abused me like a pedestrian, my lord, but I'll not do it.
Come along now, let's.
My lord, I'm sorry, it's a legitimate, my lord, concern that we have
Now,
placed.
You interrupted me at a very right time. That I must give you.
We,
At a very,
Royalists, they rely upon Shri Khan, my lord, Syed Ahmad Khan, who is the person who started this colleges from primary school to MAO. His book, The Loyal Musalman, was written, and the whole purpose of this MAO, based on that, was to create a body of educated Muslims who are loyal subjects. That is his own book. So other books may be discarded, but the founder on whom they rely has written The Loyal Musalman.
My lord, this is
And he
still,
also wrote, my lord, a book about 1857 rebellion, absolving, my lord, that Muslims were not primarily responsible. Only few people who were divergent, my lord, they were participants. So I don't know why you should object.
no, my lord, this is all
That's
secondary.
it.
Lord, basically, my lord, the
all
way in which
secondary
Bhasha
material.
was read, the
And
way in which act was read.
Even the term
okay,
nationalist.
all right,
First
now
of
can
all,
we so just, we
Nationalist
are in the
has a
midst
meaning,
of an
my lord,
argument.
in
That's all right,
literature.
we'll hear you in rejoinder. Now, Mr. Solicitor,
Another-
conclude that part
even
of the.
Bhasha, while reading Bhasha, look at this, what he says. The learned judges do not become he after retirement. Lord, they were ridiculed, my lord. I want to show that they were aware of this history, which is recorded in Bhasha. You can't pick up some paragraphs here and there and start, my lord, ridiculing the judgment. I'm leaving at that, ridiculing the judgment.
Let's have a look at
Yes.
what you have said.
My lord, if he has any objection, my lord, I'll welcome that objection. Please see, is there anything objectionable to it?
Para 14, let's see at least. We'll
Para
have to go-
17, my lord, para 17. Well, your lordship may skip 14 and 15. Please come to 17. After it is submitted that post-establishment of the AMU, the education system in the country developed in the following manner. Lord, I have given how the statutory regime changed. How someone can object to this being shown to the court? Lord, 20 Aligarh Muslim University Act is passed. Conference of Vice Chancellors of existing universities to establish an inter-university board was held in Shimla. Then 25, inter-university board was established with the following objectives. Then, my lord, 1935 Government of India Act included provisions related to regulation of higher education. It divided legislative powers between central government and provincial governments in matters related to higher education. Both the central and provincial legislature had the authority to make laws, etc., etc., my lord. Ultimately, my lord, I have said, my lord, at the end, 1952, Government of India set up an interim university grant commission, and, my lord, Act is passed in 1956. What is objectionable in this? This is, my lord, a history known to each one of us. This is the way in which regime post-independence progress.
Para 18, let's see how you
My
follow.
lord, before that, my lord, now please see, as your lordship, my lord, put a very pertinent query. My lord, kindly come to volume 2B, page 62. How, my lord, your lordships, my lord, very pertinently put that how can you show that there was a conscious decision to surrender?
2B62.
2B, page 62. Lord, this is also filed long back, including this table with relevant paginations from the material. I am just, my lord, taking care of a possible interruption.
Actually, volume 2B, page 62 is your written submission or what is it?
Yes, my lord. It's my written submissions, my lord. The title is Basha and the Character of Aligarh Muslim University. But first, 1612-1870, a private committee was set up by the name of Committee for Better Diffusion and Advancement of Learning amongst the Mohammedans of India. Then, my lord, 15th April 1872. This I have taken from a letter of private secretary to the Viceroy. My lord, please see the source, which is on record since beginning. The committee submitted its report. The report suggested and outlined the structure of a Mohammedan Oriental College. The idea behind the same was to bring the Muslims on par with current developments in the world. It emerges that one of the principal aims of the committee was the promotion of Western arts and sciences and not just religious study. Then 1873, your lordships can skip that, but I'll read for completeness. A scheme was proposed for the Mohammedan Oriental College. Sir Syed Ahmad Khan proposed that the word college in the name of MAO College be substituted with university. When the proposal is sent to the government, it replied that if a Mohammedan university is sought to be established, then no grants in aid would be receivable from the government. We cannot after Constitution, British government could and they did. Now, my lord, 24th of May, 87. Opening ceremony of MAO College is held in Aligarh. It may be noted that as per the some records, my lord, your lordships can skip the first part. Further, land of 74 acres on which the entire MAO College was set up was given by Lieutenant Governor Sir John Strachey in the cantonment area of Aligarh. The relevant portion of the said book is as under. Look, this fact is not in dispute, that 74 acres land is given by the British. This shows that national character of MAO College itself, and also shows how persons from all walks of life contributed to the proposed institution. This further shows that MAO College itself was wholly established on government land and not land acquired by minority community. This is not the only argument, my lord, your lordship. This is one of the facts I have stated. Then a letter from the secretary of MAO College notes that MAO College is an institution dependent on government funds. Then 8/1/1877, the foundation of MAO College was laid by Sir Syed on the land of the British government in Aligarh cantonment. Then, my lord, your lordships can come to 26/11/1897. I'll skip, my lord, what is not relevant, my lord. I have understood, my lord, what is being, my lord, conveyed. 26/11/1897, address by Sir Mahmud on Lord Elgin, Viceroy and Governor General of India. In his address, Sir Syed spoke of his achievements that the MAO College had made in the field of education, but lamented that the ultimate goal before it, the attainment of university for the Mohammedans of India, similar to the great English University of Oxford and Cambridge. This clearly shows that the actual aim was an open, secular, scientific institution for public good and not merely a minority institution. The minority element was a small portion of larger idea of Sir Syed. Several prominent individuals associated with MAO College propounded various different ideas for the university. I'm not reading because they were not accepted.
But you know, Mr. Solicitor, there again, your note which you have put there, that really is fundamentally inconsistent with our principles underlying Article 30. A minority institution may set up a purely secular form of educational institution. You can set up a minority can set up an architect's college. It can set up a
I
medical
bow
college.
down to that. There is no quarrel. I am, my lord,
But where you say the minority element was a small portion of the larger idea of Sir Syed, this may not be a correct constitutional test to apply.
The
We
difficulty
take it that Sir Syed's idea was to set up entirely a secular education institute.
can still be a minority.
It
I'm
still
not
can be
on
a
that.
minority institution.
My lord, I am not on that. My lord, the difficulty is we are testing something which happened in 1920 based on Article 30, which was not there at that point of time.
Just one more thing. Just read the statement. Ultimate goal was attainment of university for Mohammedans
Yes, my lord.
of India.
Correct, my lord.
So
For
that was
moment as
the
for India. My lord, therefore I have said
To
that.
that extent,
But that also does not make, as my lord the Chief Justice says, absent this also doesn't make any difference. Presence this also does not make any difference. This is a part of narration of history I am giving. I am not saying that because it was teaching other subjects or it was intending to teach other subjects, it was not a minority. That's not my argument. And please, my lord, do not evaluate 1920 Act in light of Article 30, which came subsequently. It under Article 13, if there is anything,
No, but the facts as they transpired in 1920 and before that would have a bearing on whether they are entitled to the protection of Article 30.
that's exactly what I am trying to
So we
show.
are not pitchforking Article 30 in 1920, no. In
No.
1920, they didn't have the benefit of minority status
No, even
because there was no constitution. But the facts as they unveiled in 1920 have a bearing on what is the nature of the institution.
correct. I bow down. No, your lordships are absolutely right. I respectfully bow down. Your lordships would decide whether AMU had minority status as on 1920 based upon two things: what transpired when the act was passed.
Not whether it had minority status as on 1920, as to whether it acquired a minority status as on 26 January 1950, based on the facts pertaining to its establishment. Because establishment can happen post-constitution.
Correct.
Establishment can happen
My
pre-constitution.
lord, can
So
I
we have to look at the facts antecedent to the establishment and surrounding the establishment.
please, my lord, look at
to
it
deduce
from that
what is the true
angle.
character of the institution.
Please look at it from that angle. I must give the
Right.
true facts. My lord,
Right.
I don't have the luxury of reading some paragraph from here, some paragraph from there, leaving relevant paragraph. I am giving the true
Right.
facts, historical facts. I am conscious of the fact that if it would not have been the word Mohammedan University, there would not have been any change.
difference.
Presence of that word does not make any change. This is what happened. Now your lordships may come to, my lord, 3611, my lord. At page 65. JP Habit, your lordship, have, my lord?
Yeah.
JP Habit, Lieutenant Governor of the United Provinces, writes to Harcourt. My lord, it's Lord Harcourt Butler, my lord. My lord, he is member of the Governor General's Council. My lord, a step before that, May 91, if your lordships don't mind, my lord. Just to know who the Harcourt Butler is, because he is the one who has correspondent, my lord, entered into correspondence with everyone. Some representative seeking the university met Harcourt Butler, member of the Governor General's Council, for setting up of a Muslim university. JP Habit, Lieutenant Governor of the whole United Provinces, writes to Harcourt stating that the university at Aligarh is not to be denominational, and kindly mark this, it's not to be denominational, and the control of government over the university should be evident and effective, not regulation. This was the condition. It would not be denominational, meaning thereby it would not be a minority institution. And we will have our control. Which control? Which is evident and effective. Note, this shows that from the very inception, the imperial government was clear on its stance that the demand for establishing a university by way of an enactment would only be accepted if the control substantially vests with the secular non-minority authorities. Then, my lord, next, the Secretary of State writes to the Viceroy on the need for governmental control over the AMU. He states, your telegram of the 10th June, I approve in principle of the establishment of a university at Aligarh, subject to reservation of adequate control and provision of adequate funds, and provided that my freedom of action is reserved, I sanction negotiations. Then, my Lord, Secretary of State writes to the Viceroy on the need for governmental control of the AMU. He states, your telegram of the 10th, my Lord, it's a repetition, my Lord. My apologies, my Lord. Then next, the Secretary of State communicated the readiness to sanction the creation of a university subject to the condition that its constitution was acceptable to the government of India. Well, that is the British government. This again emphatically suggests that the government was never accepting an institution formed by a particular religion. Then later by Sir Harcourt Butler to the Raja Sir Mahmud Khan, conveying the decision of the Secretary of the State regarding the Muslim University at Aligarh. In the letter, Sir Harcourt Butler points out, the Secretary of State has decided, after mature consideration, that the proposed university shall not have powers of affiliation outside the locality in which it may be established. He also conveyed that the Chancellor could be elected and that the powers which it was proposed to vest in the Chancellor should be exercised by the Governor General in Council, with one exception, namely, the professor should not be appointed without previous approval of Governor General in Council. The Raja of Mahmudabad writes to Sir Herbert Butler and states as follows. There is undoubtedly very strong opinion that objection to word Muslim is being taken by many as part of the policy of Christian nations on to crush Islam. We suggest Aligarh Muslim University, and should Hindu University materialize, we suggest for the Banaras Hindu University. These names naturally grow out of existing names of Mohammedan Anglo-Oriental College and Central Hindu College. And unless there are objections of overwhelming weight, we think it a concession that might well be made to the local sentiments, that let both of them retain their respective Hindu and Muslim names so far as name of the university is concerned. Then, my Lord, next, 26th Mohammedan Educational Conference at Lucknow. My Lord, this resolution is on record. President Major Sayyid Hassan Bilgrami, in his address to the conference, observed that the decision of the Secretary of State in transferring powers from the Chancellor to the Government of India resulted in practically making the university a government institution instead of a communal one. Well, these are all factors your lordships would bear in mind. But whether I succeed or not, that's not the issue. These are the factors which must be brought to my Lord's notice. Please see, my Lord, the resolution. This meeting views the decision of His Majesty's Secretary of State as contained in the letter of the Honorable Sir Harcourt Butler, dated Simla 9th August, with profound disappointment and regret. Having regard to the views expressed by the Constitution Committee, and in this Constitution Committee of, my Lord, Constitution of MAO, not our Constitution, in the course of discussion amongst others, 1, that the name of university should be the Muslim University. 2, with regard to the control, the powers proposed to be vested in the Chancellor should not be vested in the Governor General in Council. This precisely happened thereafter. Then 3, the powers mentioned in clause 5, chapter 3 of the statute should be the same as conferred on the patron, it should be patron under section 41 of the rules and regulations of trustees of Aligarh College. 4, this was also not followed. With regard to affiliation, the statute should remain as proposed. And 5, the provisions of the Constitution relating to the powers of the court, the council and the Senate should not be modified. This was modified. I'll show that when the act, my Lord, is brought to your Lordship's notice. And further, having regard to the momentous issues involved therein, this meeting appoints a committee of the following gentlemen with full powers and authority to act and finally settle all matters relating to Muslim University in such manner as may seem proper to them in the best interest of the community, and to wait in deputation of His Excellency the Viceroy to make all necessary representation in this behalf. Then, my Lord, next date, 6th August 1930, the Muslim Gazette, which recorded the meeting of the Foundation Committee at Aligarh, indicated that a group within the committee was willing to accept unhesitatingly whatever form of university that the government was willing to offer. Then 15, demi-official letter from Mr. H. Sharp to Sir Harcourt Butler indicated that while the proposed university would be called the Aligarh Muslim University, its setup as regards control would be along the lines of Banaras Hindu University. Banaras Hindu University had full control of the British government. My Lord, H. Sharp, my Lord, if your lordships can just note down, he is Secretary Education to the Crown. To the Viceroy, my Lord, I stand corrected. My apologies, my Lord. My learned friend, Mr. Vivedi is right. Secretary to the Viceroy. Then 24 September 1950, demi-official letter by Sir Harcourt Butler to Raja Sir Muhammad Ali, Muhammad Khan Bahadur. In this letter, Sir Butler indicates that the acceptance of government's proposal as regards the question of principle, such as control, etc., over which there has been prolonged discussion with connection with Hindu University, is an absolute condition precedent for further action. There would be a government control. Take it or leave it. Then October 15, at a meeting of the Muslim University Association, the organization votes to accept the proposal of the government for a university on the same lines as Banaras Hindu University. Then resolution of the Muslim University Committee. The following has been observed. Having regard to the refusal of the government to grant to Mohammedans a university on any principle other than those granted to Hindus, this meeting of Muslim University Foundation Committee has no other alternative at present but to accept the principles of Hindu University. My Lord, kindly note the Banaras Hindu University Act came into force on 1st of October 1915. Immediately thereafter, my Lord, they also say that, all right, we withdraw all our demands and we are happy if it is given in line with Banaras Hindu University. Then, my Lord, next, 27th August 1970, in a meeting between Aligarh Muslim University Regulations Committee and Education member Mr. Shankaran Nair, it was stated by Mr. Nair that if the government was to recognize the degrees of the college, it would also want control over standard setting in examinations. This was accepted by the Regulation Committee without objection. Members of the Regulation Committee themselves agreed to the appointment of the University Vice Chancellor being subject to veto of the Government of India. They stated that the reason for this was that the university was meant to be all India in character. It was stated as under. The reason assigned for this preference both here and in other places was that the Government of India would be free from local prejudice and that the university will be an all India institution. Sir Shankaran Nair said that Governor General in Council would act only on the advice of local government, that it would actually be to the advantage of the university to place these powers in the hands of the Lieutenant Governor, to whom they could have access and whom they would more easily be able to persuade, as indeed the Banaras University had just persuaded the Lieutenant Governor to reverse the course of action decided upon by himself and the Government of India. He also said that things were tending towards local autonomy. The members of the committee said they would prefer to wait until the time arrived. Then, my Lord, notes of H. Sharp, Secretary, Department of Education, Government of India, while discussing the draft constitution of the proposed university. Lord, please, my Lord, allow me to read this. Lord, this would have bearing, my Lord. General principles which should regulate the organization of the university. I suggest two, which should be kept in mind during further negotiations. One, the Banaras precedent should be followed, save where the promoters desire a change which is unessential or an actual improvement. Such changes as the omission of the syndicate and unicollegiate character of the university. Adherence to the constitution of the Mohammedan Anglo-Oriental College should not be permitted, as an argument in support of mischievous departure from Banaras model or relaxation of essential conditions. The arguments was actually used by members, that is, in the matter of dismissing staff. But such an argument entirely overlooks the fact that a college is not a university and that a certain amount of wholesome control has hitherto been exercised over Mohammedan Anglo-Oriental College by the University of Allahabad. Similarly, as a minor consideration, the argument put forward that Allahabad is a government university should not be permitted to weigh in. The statement is incorrect and the implication is misleading. Then main political considerations. The promoters undoubtedly have political as well as educational aims. They would like to spread a network of Islamic colleges over India affiliated to Aligarh. But they know this will not be allowed and have wisely chosen a unicollegiate form of university. They will possibly attempt to make Aligarh a center of Muslim political movement, perhaps a pan-Islamic movement. This can be guarded against by insisting in a reasonable composition in the governing bodies, proper conditions for admission, and a wide framing of Clause 6 in view of possible political activities. They have all along desired network of Islamic schools recognized by the university. They have now wisely abandoned the claim to recognition. Proceeding paragraph 11 and 33. They want to be free of all control by Lieutenant Governor, partly as a matter of izzat, that is respect, partly because they anticipate greater leniency from the government of India. See proceeding number so and so. It would seem from paragraph 7 that they were willing to give way on this point. Afterwards, they took counsel together and stiffened. But I think they will give way if pressed. The plea of an all India institution can be countered by the Banaras analogy. Then, my lord, your lordships can, my lord, consider skipping, unless except, my lord, at page 70, the underlined portion, my lord. The bill. The education aspects of the case can best be dealt with during the consideration of the documents. The notes and proceedings touch all the important points. I comment below on the following, on the proceedings. Power of Governor General in Council, proceedings paragraph 17, the proposed clause 6 is insufficient. Clause 19 of Banaras bill should be reproduced. Power of the visitor. I do not see how the wishes of the promoters not to have a visitor stall can be met. There would immediately be an outcry from the Hindus. The Lieutenant Governor should be visitor and should have the powers given in section 6 of the Banaras Act. The visitor should also have the power of sanctioning statutes and regulations as in section 17.5 and 18.5 of the Banaras Act. See proceedings so and so. I'll show, my lord, from the provisions which were not shown to your lordships. The court is not the final body for all statutes. I'll show that, my lord, when I come to that. Then powers of the court. The following powers of the courts are excessive and should be disallowed. The power of interpretation, the sanctioning of regulation, etc. Senate and syndicate. There will be no syndicate. This is not necessary, provided a subcommittee can be appointed, proceeding para so and so. If the power of the court are properly curtailed, those of the Senate appear sufficient, but should perhaps be made subject to the act, etc., etc. Then your lordships can, my lord, skip and please come to page 72. 1918. Later by Sir, your lordship gets, my lords. Later by Sir E.D. Maglan, Secretary to the Government of India, to the Chief Secretary to the Government of United Provinces. My lord, this is, my lord, a part of the record, volume 4D, PDF page 1089. The letter is placed on record. As his honor, the Lieutenant Governor is aware, the Government of India wrote a war during the year 1911-12 in correspondence with the Secretary of State regarding proposal to establish a Muslim university at Aligarh, and the Secretary of State communicated his approval of the institution of the proposed university subject to certain remarks. and criticisms put forward by then under discussion. The principles then indicated by the Secretary of State have formed the basis of Banaras Hindu University University Act 1915, and it is a university. It is now presumed that any legislation for the establishment of a Muslim university at Aligarh must conform in all matters of substance with the provisions of the legislation already passed by the Hindu University at Banaras. At a meeting of Muslim University Foundation Committee held at Aligarh on 8th April 1917, it was resolved that committee was prepared to accept the best university on the lines of Hindu University, and authority was given to the regulation committee of the proposed Muslim university to take the necessary steps for the introduction of a Muslim university bill in the Imperial Legislative Council. Now your lordships may directly come to, my lord, page 75. My lord, this is in the same lines, that government control, no denominational character, and my lord, page 75. No, my lord, denominational character, B, absolute government control, and C, at par with and on line of BHU. Lord, page 75, 8/5/1920. Telegram from the Secretary to the Government of India, United Provinces, Judicial Department to Secretary to the Government of India, Department of Education. The telegram compares the BHU Act and draft bill for AMU. On a comparison, it notes the following. Lord, please see 2, A2, a comparison of Muslim University draft bill with Banaras Hindu University Act shows that 2, alterations, additions, amendments or repeal of statutes and B, ordinances in the case of Muslim University bill that is subject to the veto of Governor General in Council, while in case of Banaras Hindu University, they require the previous approval of the visitor. That they have, AMU had omitted that. He objects to that. It is also noted that certain powers vested under the Banaras Hindu University Act in the visitor have, according to the draft Muslim University bill, been transferred to the Governor General in Council. In other words, while official control in this respect is in no way affected, only the agency exercises that control is changed from local to imperial government. Now, bearing in mind the fact that Aligarh and Banaras universities are all India and not merely provincial institutions, and that in future, as a result of the scheme of constitutional reforms introduced under the Government of India Act 1919, these two universities will be not provincial but central subjects. It is necessarily follows that the proposed modifications are not only in no way opposed to principle, but in the highest degree desirable. This were the seeds sown for entry 63. Then it follows, therefore, that unless the modifications proposed in the draft Muslim University bill are retained, the Government of India control over these two universities will really be nominal, and as a result, the very object for which the Aligarh and Banaras universities are constituted as a central subject will be defeated. What in fact the proposed draft does bring about is that while leaving sufficient measure of control in the hands of the local government, insofar as it is at all necessary, it tightens the control of Governor General in Council over these all India universities. The account of the university will include expenditure of the imperial recurring grant. These must therefore be submitted to the Government of India. New statutes and ordinances will be framed by virtue of power given by the Imperial Act to a university constituting a central subject, which will, under the reform scheme, be under the control of the Government of India and not under the provincial government. These must therefore be subject to the veto of Governor General in Council and not of the local government. To enact otherwise would result not only in the abdication by the imperial government of its own powers as well as responsibilities, but may also lead to undesirable results. Now, your lordships may kindly come to page 77 at the foot. Now, my lord, the bill is introduced. My lord, which your lordships, my lord, I said the second limb would be after the history, what happened in the imperial parliament, in the, my lord, when the bill was passed. Ultimately, Mr. Shafi, my lord, who was one of the liberals, he introduced the bill. He seems to be a member of this imperial parliament also, imperial council also, I'm sorry. Your lordships have, my lord, bottom of page 77.
77.
Discussion on the AMU Bill 1920, my lord. That is, my lord, Imperial Council. That is, my lord, delegate of the Parliament, British Parliament. Mr. Shafi introduced the bill for the establishment of a university and moved to refer the bill to a select committee. The relevant extracts of his speech are as follows. This was the reason why I said that Mr. Shafi led one group and Ali brothers led other group. That was the only relevance. The Secretary of State on 18th July approved the principle of establishment of such a university subject to reservation of adequate control and provision of adequate funds, and while reserving his own freedom of action, sanctioned the proposed negotiations with the association. Meanwhile, the Hindu leaders, who too had in their turn approached the government of India with a scheme, the establishment of a Hindu university at Banaras, guided by the practical spirit, within bracket, which is one of their characteristics. This, I don't know, it's a compliment, I take it as a compliment. Practical spirit, which is one of their characteristics, accepted the conditions laid down by the Secretary of State, with the result that a bill for the establishment of Banaras University was prepared, and after having passed through the Imperial Legislative Council, received the assent of the Governor General on the 1st October 1915. An undertaking was at that time given by the government to the Hindu leaders that the university to be granted to the Muslim community would also be on the same lines of Hindu University Act. This position, as clearly explained to the Muslim leaders and the government of India, have all along been ready and willing to act up to that undertaking, and the government, they say on the floor of the parliament that we will be at par with Hindu University. There cannot be anything more to suggest that they surrender their right to continue as a minority institution. Then further, honorable members are aware that education, including university education, has in the past been a provincial subject. Legislation regarding the Banaras University was framed in consonance with the state of things, and all official control, in consequence, reserved to the provincial government, recognizing the all India character of Banaras and Aligarh universities. The rules framed under the new Government of India Act have now proposed that these two universities should be central subject, and the responsibility in connection therewith will henceforward rest on the shoulders of the Government of India. Now, your lordships, my lord, kindly come to, my lord, next page, Sayyid Muhammad Ali. No, my lord, he is not one of those Ali brothers, but a different Muhammad Ali. My lord, which is at page 79. Does your lordships get, my lord? I'm skipping something which might, my lord, at times become boring without rendering any assistance. Sayyid Muhammad Ali, a university, they pointed out, must be a national organization calculated to subserve the various and varying needs of the different communities, their cultural genius, and their industries and their trade, which are to be served by it. About the former, the Muslim community has felt compelled to accept the later academic opinion there is no room in future for an affiliating type of a university, and that the best interest of educating will be served by a local university. Regarding the latter, the community has reluctantly accepted the limitation of the control imposed by the government. I should like to draw attention to another important point. The Mohammedans have always felt the need of secular education being supplemented by religious instruction. They have always felt that nothing can be more deplorable, more subversive of discipline, more detrimental to the development of entire manhood and character than to train and educate the youth of the country in godless education. It is therefore a matter of satisfaction that promoters of the scheme have made religious and moral instruction the bedrock of education. The bill provides that students of all classes and creeds would be admitted to the university, and it is hoped that the university will be a means of better mutual understanding between various communities of the country. He also expresses the need, etc. Then, my lord, it is referred to the select committee, and now we are in the select committee's report. My lord, at page 80. The committee inserted a provision in clause 30, which provides that the first ordinances shall be framed in accordance with the directions of the Governor General in Council. Please pause here for a moment, my lord. My lord, these are the documents of governance. Statutes and ordinances are the documents of governance which are framed by the Governor General in Council under the Act. In clause 30, we have inserted a provision as to the first ordinances which shall be framed in accordance with the directions given by the Governor General in Council. The full control thereafter, my lord. We have also substituted the Lord Rector as the authority who shall nominate a High Court judge on the board to settle disputes between the Executive and Academic Council as to the power of making ordinances. This we have done so as to have wider field of selection than would have been possible if the authority has been one having no power of selection outside the United Provinces. In clause 35, we have substituted the visiting board for the court as the authority to appoint the auditor, etc., etc. My lord, I may not, my lord, further detain your lordships any further. Now, my lord, Mr. Shafi comes back, my lord, now the report comes before the Imperial Council again for discussion. That is 9 September 2020 at the foot of page 80, my lord. Mr. Shafi moved the report of the Select Committee on the bill to establish AMU. Khan Bahadur Ibrahim Harun Jafar proposed an amendment that the First Chancellor, Vice Chancellor, and Pro-Chancellor shall hold office for such period as the court may determine. Court, my lord, means the court as an authority under the Act, my lord. Mr. S. Muhammad Ali responded as follows. My lord, the amendment, if carried, would result in creating an anomalous position, both as regards the highest offices of the university and as regards the Governor General in Council. It would be ridiculous if the court, immediately after the appointment by the Governor General in Council of the First Chancellor, the Pro-Chancellor, and the Vice Chancellor, sets aside this appointment and makes fresh appointment. Is hardly conceivable that any person would consent to accept any of these honorary offices under the university under those conditions. You can't have the Governor General in Council appoint 3 highly placed persons and next day the court removes them. So he says that is not acceptable. Now, Shafi, my lord, Mr. Shafi repeats that, my lord, in different words. I am not, my lord, reading them. Then your lordships, my lord, kindly come to the bottom of page 81. It was opposed by Mr. Shafi as follows. My lord, a careful examination of clause 30 as it stands in the bill will show the honorable members that the acceptance of my honorable friend's amendment will result, firstly, in deletion of subclause 2. Your lordships can skip. Come to my lord, next page, highlighted part. In the third place, my honorable friend would like the word veto being substituted for what in effect is precious approval of the Governor General in Council. Here against the Government of India are unable to accept the change proposed by my honorable friend. It will be noticed that previous sanction in the expression used in the Banaras Act, and we have in fulfillment of the pledge given to Hindu leaders at that time, in this respect, adhere to the phraseology adopted in the case of Banaras Act. The Government of India are not prepared to depart from the decision then arrived at. Government of India means, my lord, the then British government. Now, your lordships, my lord, kindly come to the scheme of the Act, my lord. Page 85. And, my lord, allow me to, my lord, read the scheme, my lord, the way I see the scheme, because unfortunately, many provisions were not pointed out to your lordships or pointed out only in part. AMU Act as it stood in 1920. Does it?
Yes. Page 85, right?
Yes. Lord, 119. Lord, allow me to read this, Lord. I have paraphrased my arguments also with quoting the relevant provision, Lord.
Bottom of page 85. Page 85?
Page 85, Lord. The
Right.
title is the AMU
AMU
Act
Act as it stood in 1920.
as it stood. Because your lordships would examine the as it stood then, whether any status was conferred. The survey of provision of the Aligarh Muslim University at the time of inception of the university in 1920 clearly points towards a predominantly national and non-minority character of the university. In fact, the minority element was only present as an exception or a carve-out as opposed to the omnipresent non-minority character. A copy of the Aligarh is annexed. At the time of its inception, Section 3 provided that the first chancellor, pro-chancellor, and vice-chancellor were to be appointed by the Governor-General in Council by way of a notification in the Gazette. The Governor-General in Council being the appointing authority at the time of inception of the high positions of Chancellor, Vice-Chancellor, to be reflected through a notification of India is asymptomatic of a national character. Section 30 is quoted above. My lord, I will not read that. Then, my lord, 121. Section 5, which provided for the powers of the university, had 12 subclauses, out of which 10 were clearly non-minority. My lord, Mr. Sibal read only one of the objects out of 10. My lord, allow me to read the whole. Dr. Dhawan, my lord, I'm sorry. Section 5, my lord, at page 86. The university shall have the following power, namely, to provide for instruction in such branches of learning as the university may think fit, and to make provision for research and for advancement and dissemination of knowledge, to promote Oriental and Islamic studies and give instruction in Muslim theology and religion, and to impart moral and physical training, to hold examinations, etc., etc. The only part which is religious, which is denominational part, because the Britishers were saying that will not accept denominational character, is, my lord, at the end of 12, which was read before your lordships. I'm not reading others. They are non-religious or non-denominational. 12, to do all such other acts and things, whether incidental to the powers aforesaid or not, as may be requisite in order to further the objects of the university as a teaching and examining body, and to cultivate and promote art, science, and other branches of learning, including professional studies, technology, Islamic learning, and Muslim theology. So the Look, my purpose, my lord, at the outset is, please take a holistic view. The history, the historical background in which the act comes into force, and the act also holistically, my lord, one provision or two provision may or may not make it a minority institution. I am, my lord, respectfully urging that the Britishers were very clear that it would be non-denominational and it would have our full control. If these are the two things, my lord, then it is not a minority institution.
And this. It's 20.
What was that?
Yes.
My lord, 8, your lordships have seen this, my lord. The university shall, subject to provision of this act and the ordinances, be open to all persons of either sex and of whatever race, creed, or class. My lord, I straightway, my lord, consider as a proposition of law, a minority institution can be open to everyone, my lord. That would not, my lord, rob it of its minority character if otherwise other, my lord, attributes are satisfied. But please see 30. Ordinances. The executive council or in academic ordinances matters, the academic council may make ordinances. The first ordinances shall be framed as directed by the Governor General in Council and shall receive such previous approval as he may direct. Correct, Manoj? Not by the committee, not by the court, not by anyone else. He says non-denominational, government-controlled ordinance will be the first ordinances. And I'll show how it can be amended. It can't be amended without his approval. No new ordinance or amendment or repeal of an existing ordinance shall have any validity until it has been submitted through the court and the visiting board, which may record its opinion thereon to the Governor General in Council and has obtained the approval of the latter, who may sanction, disallow, or remit it for further consideration. See, my lord, the absolute power. My lord, same provision is for statutes also. So unlike what was submitted before your lordships, that I make statutes, I am the court and court is 100% Muslim, which is of course deleted now in view of the new constitutional setup. Incidentally, it may be. De facto, it may be, but de jure, my lord, it is not necessary that court should be consisting of only Muslims. If any question arises between the executive and the academic council as to which has the power to make an ordinance, either council may represent the matter to the visiting board, who shall refer the same to a tribunal consisting of 3 members, one of whom shall be nominated by the executive council, one by the academic council, and one shall be a judge of a high court nominated by the Lord Rector. Lord, complete governmental control, outside control. Kerala bill, your lordships would remember, say sprinkling of outsiders. Complete control on administration by the minority community with sprinkling of outsiders. Now, my lord, further, if my lord, 32, admission to the university. My lord, this is the heart of any university administration. How to admit students. How to judge their suitability to be the student of this particular university. admission of students to the university shall be made by an admission committee consisting of the Pro-Vice Chancellor, the principal of an intermediate college who shall be selected by the Vice Chancellor, and such other persons as may be appointed by the Academic Council. Students shall not be eligible for admission to a course of study for a degree unless they have passed the intermediate examination of an Indian university incorporated by any law for the time being in force, or an examination recognized in accordance with the provisions of this section as equivalent to the intermediate examination, and possess such further qualifications as may be prescribed by the ordinances. Again, my lord, framed above. The conditions under which students may be admitted to the diploma courses of the university shall be prescribed by the ordinances. Court can do nothing to the ordinance except suggesting some amendment which can be discarded, which can be disallowed or remitted back. The conditions, the university shall not, save with the previous sanction of the Governor General in Council, recognize for the purpose of admission to a course of study for a degree as equivalent to its own degrees, any degree conferred by any other university or as equivalent to the intermediate examination of an Indian university, any examination conducted by any other authority. Notwithstanding anything contained in this act or the ordinances, any student of the Mohammedan Anglo-Oriental College, Aligarh, who immediately before the commencement of this act was studying for the examination of Allahabad, no, that's the transitory provision, nothing turns on that. Then 124.
23 may be read.
123. Section 9, on which considerable reliance has been placed, also merely creates an island of minority education by giving the power to the court to make statutes making institution in Muslim religion compulsory only for Muslim students and not otherwise. This provision does not define the predominant character of the institution at the time of its inception. My lord, I'm thankful, my lord, to my learned friend. After the constitution, to make it Article 29 compliant, this is deleted in 1951, 70 plus years back. This is deleted by the parliament, by Indian parliament, to bring this in conformity with Article 29 of the constitution.
29?
28.
28,
I said
not 29.
28. My apologies.
But that will in fact show, or probably it was a minority institution,
Show of
that it was probably a minority institution. Because otherwise state funded institutions, religious education is not permitted.
correct. The provision concerning teaching of the university at the time of its inception also overwhelmingly includes only secular education, which is evident from the fact that it is include lecturing, laboratory work, tutorials, etc., etc. Now, my lord, please see the actual governance documents. Para 125. As per section 27, statutes could provide for conferment of honorary degrees, appointment of rectors, institution of fellowship, scholarship, the conditions of appointment of officers of the university, etc. But the first statutes of the university were framed not by the court, but by the legislature as set out in the schedule to the original act in terms of section 28. Therefore, the first statute at the time of inception, which could have provided for wide array of powers and functions and administration, section 30 subarticle 1, article 30 subarticle 1, administration, when it is established, what is the position? Within the university were not framed by the minority, but by the federal legislature itself. Further, as per section 28, the said first statutes framed by the federal legislature could be amended, please note this, repealed or added by the court only after it had been approved by the Governor General in Council. Now the Governor, my lord, now there is an amendment because there is no Governor General in Council. Now Governor of the state, Governor of Uttar Pradesh. Amended, repealed or added by the court only after it had been approved by the Governor General in Council, who also had the power to disallow proposals for amendment of such statutes. It's not binding. It's not like, my lord, the resolution passed by the cabinet that the governor is bound. He can only refer it once. No, he can straightway say that I don't agree. I reject it. I'll show that provision also. The only carve out from this power of the Governor General is Council was that statute dealing with instruction of Muslim student in Muslim theology were not required to be submitted for approval. Rest everything goes for approval to the governor having full power to reject it. Therefore, while the statutes and the power to control the statute predominantly vested in a non-minority authority, only a small portion as a sprinkling minority were provided. My lord, now please see, my lord, section 23. My lord, before that, my lord, please see section 28, statutes. The first statutes were also provided by the legislature. It was not left to any body, academic council or executive council or even the court. So at the time of establishment of AMU, no decision making was done by anyone other than the legislative council. First ordinances, first statutes, and both the documents of governance. It's a part of the act itself. Now please see, my lord. This is section 28. My lord, now I take your lordships, my lord, to the some of the other provisions of the act, my lord. Please see page 148 and 149 of this very my lord, document. The London is right, my lord. I'll just, I skip, my lord, some provisions. Before that, thereafter, I'll come to, my lord, page. Kindly come back to page 89. I'm sorry, my lord, my apologies to your lordships. My lord, para.
Mr. Mehta, the term used in the constitution is administration.
Yes, lord.
Now, administration.
Administer.
Administer. Now, the issue would be whether day-to-day task of administration or administering the institution is vested with the community. That will be the test, or it will be the test to see, as pointed out by some of the councils on the other side, de facto who had the control, who were in charge and taking decisions. You may be right. As far as the first ordinances, etc., as pointed out by you, these are all made by the government had a big role to play in it. We don't know what really were the nature and structure of those ordinances.
I'll show that. I'm going to show that. And even
And
those.
just keep in mind also Article 28 and the bar created or restrictions created by that. Because Article 28 clause 1 says no religious education, etc., in the fully government aided institutions.
Yes. But that's going to be, yes, but that's why there is an amendment.
And that's why I flagged when you referred to the deletion made by 1951 amendment in terms of, that is really in terms of clause 3 of Article 28.
Yes, it says so.
Because it gives an option to.
Voluntarily you can't be compelled.
Voluntarily, compulsorily
You can't be compelled, you can voluntarily have that. Lord, then ordinances, my lord, page 90 at the foot. As I said, my lord, first ordinances are framed by the framed as directed by Governor General in Council, etc. My lord, I have read, my lord. Please, my lord, come to page 91, section 12. Your lordship gets, my lord? I'm sorry, my lord.
Even amendment.
Page 91, section
Page
12,
nine, page 91,
section 12.
section 12.
The university shall, subject to the statutes, have power to establish and maintain intermediate colleges and schools within such limits in the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for admission to the university, and may provide for instruction in Muslim religion and theology in any of such colleges and schools, with the approval of the academic council and the sanction of the Governor General in Council on recommendation of the visiting board, the subject to such conditions as may be prescribed by the statute and the ordinances, the university may admit intermediate colleges, etc. The purpose is that decision making is not in the hands of a body having Muslim majority. My lord, administration is not, my lord, a peon is also a part of the administration, a clerk is also a part of the administration, but when we are talking of an institution like university, administration is the body which administers the university. The rest of the people would do their part assigned to them as decided by the administering body. Lord, otherwise, my
The
lord,
reason I asked that question was prior to 1947, the British government could have established an institution and also, formulated the role of the people, but given the administration to the Muslims or the Hindus.
my lord, because of a request which I read that I don't insist, you don't want to make it, but please, you have respected local sentiments in Hindus, respect local sentiments of Muslims, not with an intention to make it a minority institution. Therefore, my lord, I read that inclusion of Muslims, which is also, my lord, deleted subsequently, I'll show that. But right now I am on 20 Act as it stood on 20. That was also, my lord, with a review to respect the sentiments, not with an intention of conferring any status. Banaras Hindu University had the court having Hindus. So it was more, my lord, out of a gesture of goodwill rather than, my lord, conferring any enforceable right on the institution. So then section 13. The Governor General shall be the Lord Rector of the university. The Lord Rector shall have the right to cause an inspection to be made by such person or persons as he may direct of the university, its buildings, laboratories and equipment, and of any institution maintained by the university, and also of the examinations, teaching and other work, etc., etc. My lord, everything is conferred upon the Lord Rector, but please see subsection 5, where the court does not within reasonable time take action to the satisfaction of Lord Rector. Now, my lord, it is governor. The Lord Rector may, after considering any explanation furnished or representation made by the court, issue such directions as he may think fit, and the court shall comply with such directions. Complete predominant supervening powers conferred upon the governor, because it has always been the desire and stated wish of the Britishers that we will have effective government control. You accept it or you do not accept it. And this is where the government control is accepted, my lord, reflected. Then, my lord, annual accounts will also be, my lord, placed before the visiting board and Lord Rector, my lord, non-Muslim bodies, and to be published in Gazette of India. Then, my lord, last is section 40, power to remove difficulties. If any difficulty arises with respect to the establishment of the university or any authority of the university, or in connection with the first meeting of any authority of the university, the Governor General in Council may, by order, make any appointment or do anything which appears to him necessary or expedient for the proper establishment of the university or any authority thereof, or for the first meeting of any authority or university. Any such order may modify the provisions of this act and the statute so far as so and so, so and so. Now, your lordships, my lord, kindly come to page 139, the act, my lord, and some provisions which are not quoted here.
139.
139, no, again, it's an act, printed act. They do not say that we merge or we recognize your existence and convert you into the university. My lord, there are two types of legislations. My lord, please, my lord, bear one fact in mind, and this is, my lord, going to the root of the question when your lordship ultimately decides the issue. My lord, some legislations can be legislations which recognizes an existing fact. I'll show, my lord, those. There are some universities where such things have happened. And some legislations which in law establishes or incorporates something new. A new entity comes into being. A new entity is born. This is a legislation where it's not recognizing anything. It establishes and incorporates a new entity. And this judgment in Basha is only 1920 Act specific. It does not lay down a law of universal application, that once you are incorporated, you are not a minority institution. I'll also show, I'm sorry.
Yes.
Other side reads Basha to mean that if you are incorporated as an university, from date of incorporation, your minority status goes. That's not what Basha holds. Basha merely examines at 1920 Act and says that you are not the university which is minority university. My lord, I will show examples post constitution also. Minority universities can be incorporated. How? That I'll show. Please see, my lord, the preamble. Whereas it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh. So the purpose is to establish and incorporate. By whom? Lord, by the legislature. Not only a new body is born, the earlier body goes by operation of law. It merges, it dies. You are not. It is dissolved, my lord. The correct word is not merger, it's dissolved into this new entity. It dies, my lord. So, new body takes birth by operation of law. It is established by operation of law, incorporated by operation of law, and this is what it says. Whereas it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh and to dissolve the society registered under the Societies Registration Act, because there cannot be two statutory bodies simultaneously. Therefore, one is born, another gets dissolved, it dies. Then your lordships and my lord kindly come to section 4. I'm sorry, my lord, page 140. Section 4. Your lordships are on section 4, my lords.
Yeah.
I'm grateful, my lord. The society is known as Mohammedan Anglo-Oriental College, Aligarh, and the Muslim University Association shall be dissolved, and all properties, movable and immovable, and all rights, powers, and privileges of the said societies, and all property, movable and immovable, and all rights, powers, and privileges of the Muslim University Foundation Committee shall be transferred to and vest in the university. And please mark this, my lord, this is relevant, and shall be applied to the objects and purposes for which the university is incorporated, not for the objects and purposes of either MAO or other institutes, which gets dissolved, which dies, and the new body takes, my lord, birth. Now, your lordship, my lord, kindly come to page 140.
Just stopping here for a minute.
Yes, my lord.
NAO College
Yes.
and the Muslim University Association, as per your argument, even they may be a minority institution in terms of Article 30, but after they got dissolved into it, they cease to be, that character will not be relevant.
No, my lord, I would put it slightly differently. My lord, they had a denominational character. There was no Article 30.
No, I know, but if we applied Article 30
Yeah,
to
yes.
them, if we
They
applied.
may have denominational character, but in view of the peculiar historical facts which Basha notes, once you agree to the terms and conditions of the government, and Parliament by an act of legislature dissolves your existence and gives birth to a new body, the earlier one goes.
First, this is your first, in fact, the first one was earlier, they agreed to give up certain rights, and therefore, and the second was the incorporation or the establishment.
Surrender the rights. That's how, that's the ratio of Basha.
But as far as MAO is concerned and Muslim University Association is concerned, they were distinctly a minority in case we applied Article 30.
May have been, my lord, may have been. But they could have, my lord, I'm answering it straight. They could have continued even if they were minority institutions, as minority institutions, the way St. Stephen continued, the way, my lord, Jamia continued, the way many other, my lord, linguistic establishments continued. There were many linguistic, my lord, not establishment, institutions, which were, my lord, continuing, and their degrees were more valuable. My lord, this Roorkee may not have been, my lord, a minority institution, but there were minority institutions. St. Stephen is the best example. Closest, my lord. The Delhi University was incorporated simultaneously with Allahabad University, merged, 5 universities were merged into one, and this continued its independent minority existence. At that time, even St. Stephen had an option of going before the British Crown and requested, pass an act for me. And British Crown would have said that these are my conditions. You will not be denominational Christian institute. You will have a full control of the government. If you agree, we'll consider your plan. That's what, my lord, Herbert Harcourt Butler says, that we will consider. Permission is given to consider your negotiations. All objects go, everything goes, because it says that now the money would be spent for the objects of this newly born statutory body.
Do you have any material on record to show that what were the recurring expenditure of the university from 1920 to 1950 and who funded those?
My lord, as of now, my lord, the government funded, the figure, my lord, I can take it, but as of now, it's 1,500 crores per annum.
To 1950.
1950. My lord, My lord, I'll try and find out. There may be
Registrar
something on record.
of Aligarh, my lord, that it was about 25%. This is, I mean, instruction.
We will check up, my lord. We'll say as per.
Recognized by the government.
No, it. Yeah, that's okay. That's okay. My learned friend is arguing some other matter between the two of us, my lord. My lord, Saint Stephen is decided to be minority institution by a 5-judge bench of this honorable court. So I cannot make any other submission, my lord. And if I have other submissions, I'll make in appropriate proceedings at an appropriate time, my lord. My learned friend cannot, my lord, apply the estoppel rule against me. Yes. My lord, please see, my lord, page 143. Why everything was surrendered? Apart from, my lord, their political affiliation, I'm not going into it. They were loyalists to the British. They were entitled to be. Anyone, my lord, can be loyalist to either A, B, C, anything. I'm not, my lord, on any value judgment. But they wanted recognition of their degrees. That is section 6 of this act. The degrees, diplomas, and other academic distinctions granted or conferred to or on persons by the university shall be recognized by the government. I'm sorry. My lord, eminent universities and eminent institutions were conferring degrees. Only thing was not recognized by the British government. Now, please see 6, my lord, I'm sorry. I'll read it again. The degrees, diplomas, and other academic distinctions granted or conferred to or on persons by the university shall be recognized by the government, as are the corresponding degrees, diplomas, and other academic distinctions granted by any other university incorporated under any enactment. Please, my lord, underline this portion. The degree granted by AMU would be at par with degree of any incorporated university, not Gujarat Vidyapith, not Vishwa Bharati, not any other institute, but by the bodies, my lord, which are by the universities which are incorporated by the British sovereign, that is the Parliament. Now, your lordships, my lord, kindly see 146, my lord. My lord, visiting board, my lord, section 14. Please see, my lord, visiting board. The visiting board of the university, if and when the United Provinces of Agra and Awadh becomes a governor's province, Awadh, my lord, why should we say Awadh, my lord? The Britishers were unable to pronounce, therefore they used to say Awadh. It's Awadh, my lord, as our Agra and Awadh become a governor's province within the meaning of the Government of India Act, shall consist of governor thereof, the members of the Executive Council, the ministers, one member nominated by the governor, and one member nominated by the minister in charge of education. No Muslims.
See section 7, by the way, apropos what fell
I'm
from my learned brother Justice Surya Khan,
Yes, ma'am.
it's a very interesting provision. Because I was trying to track whether this act had any provision for finance. It has no provision for finance. It has a provision for audit and accounts, but no provision for finance. See section 7. The university.
I'll read.
Yeah.
Your lordship need not. The university shall invest and keep invested in securities in which trust funds may be invested in accordance with law for the time being in force relating to trusts in British India, a sum of 30 lakhs of rupees as a permanent endowment to meet the recurring charges of the university other than charges in respect of fellowships, scholarships, prizes, and award, provided that any government securities as defined in the Indian Securities Act 1920, which may be held by the university shall, for the purpose of this section, be reckoned at their face value. The aforesaid sum of 30 lakhs shall be reduced by such sums as at the commencement of this act, the Governor General in Council shall, by order in writing, declare to be the total capitalized value for the purpose of this section. All permanent recurring grants of money which have been made either to the Mohammedan Anglo-Oriental College, Aligarh, Muslim University Association or Muslim University Foundation by any ruler of a state of India, and of the total income accruing from immovable property, not being land or buildings in the occupation and use of said college, which by operation of this act has been transferred to the university. But
So does section 7 mean that the entire 30 lakhs, which was the initial corpus, was really what was transferred from the erstwhile MAO and the Muslim University Association?
4 also says that. Please see, my lord, 4, once again, my lord, 4 also says that. Therefore, my lord, I say that while dissolving one body, the act will have to do something about the property of that body.
But the entire corpus of the university therefore came from the MAO
My lord, good.
and the
My
Muslim
lord, I'm
University
sorry.
Foundation.
I'm sorry, my lord, factually it's not correct, my lord, but what, my lord, would be necessary would be establishment and administration.
Not
An
finance.
entire, yes, my lord, not finance.
Establishment, the finance would have some bearing on establishment, right? The person who has established, if they have contributed to the finance, that's a very important indicator.
30 lakhs
The
came
initial
from
stage.
them, my lord.
30 lakhs came from several people, including Hindu Rajas, Hindu kings.
What has been transferred includes the recurring grants also which were being given. to
I'll
the-
give that bifurcation of 30 lakhs. But from the record, I'll show that. The government land is 75 acres. Do you please give the value of that?
Record, I didn't want to interpret whether it fell.
Not once the
I'll
land
show
is
from the record.
transferred, it becomes the land of the college or university. So there's no point saying it came as a grant, but it became the exclusive property
Naturally.
of MAO and then the
So just
university.
visualize if I would have done it. What they are doing it.
What?
No.
I
My
can
lord,
never visualize.
there was a barrage, my lord.
I could
Here we are merely pointing out few things.
We'll continue tomorrow.
I could never.
Tomorrow, my lord.
Roughly,
Grateful.
Mr. Solicitor, how long will you take tomorrow?
My lord, I'll take about, my lord, 3 hours. My lord, I can assure your lordships not to repeat anything, and I'll attempt not to be boring also.
That's just an attempt.
They'll also ensure that.
Yes, sir.
But would it be possible for you to finish by tomorrow lunch, if we say?
May
Because
not be possible.
Because
May-
3 hours would take us to about, say, 2:30. So we
May
were just
not
saying
be
if you
possible.
can wrap up by lunch, it would be
My
nice.
lord, there are other points other than this, my lord, for which, my lord, I'll.
And
give some
thereafter,
time to assess.
Mr. Kaul will take, Mr. Dwivedi will argue or Mr. Kaul, who will? Hour and a half after this?
There's something I need to show about the judgments.
All right. Mr. Dwivedi is also there.
Mr. Dwivedi, Mr. Guru Krishna Kumar, my lord,
I, my lords, I won't repeat, my lords. I was looking at 1.5, but I think I'll reduce myself after all this is done. I'll reduce myself.
We were looking at whether we can wrap up arguments on this side by tomorrow evening.
but that
Maybe a
is,
little
that,
difficult, little difficult.
that may not be
Little-
realistic, even if we
Maybe
say
a
yes.
little spillover to day after tomorrow.
That's right.
But day after tomorrow is Thursday. which is a
Good,
miscellaneous
go
day.
to, my lord, and.
Right.
Oblige.